Good morning, everybody. My name is Judge Kim Teresa Malika, your in-first appearance magistrate court. Today we're going to determine if there's probable cause. Today is not your trial day. Please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney. I believe we have Mr. Romero, who's at the main jail, and we have Mr. Reedy, who's over here to my right in the courtroom. If you have a private attorney, please, when you first step up to the podium, state your name, and let me know that you have a private attorney. Jill wants us to
Peterson, is that a state piece?
We're going to take Derek
It's an MO.
Peterson. That one yours? Yes. All right, so we'll pass that.
We can barely hear you. We probably can hear anything from the speech.
Okay, then I'll say it again. Thank you. Huh? Okay, so I'll just put these. Who didn't you say? Yeah, we did Peterson. Okay, who can hear me at the main jail? Raise your hand. Everybody can hear me. Did you hear what I just said? You need me to repeat it? Raise your hand. No. Okay. All right, Derek Peterson, please. Good morning, Mr. Peterson. How are you?
Fine, Judge.
Can you hear me okay?
Yes, sir. Yes, ma'am.
Okay. All right, sir. We have Mr. Odom here who's representing you.
Good morning, Your Honor. George Odom on behalf of Jira, law officers of Jira McLawrence.
Okay. All right, sir. You have soliciting, display on right-of-way, and possession of drug paraphernalia. What are we doing with this, Mr. Odom? We can resolve it? Or?
Judge, if Mr. Peterson cares to resolve, I do have a potential PC argument, but before I get into that, I think Mr. Peterson is going to want to resolve, but if not, I do have a PC argument concerning the stop and search. Mr. Peterson, are you looking to resolve your case this morning?
Yes.
Judge, if the court was inclined to get involved, I would ask the court to, on count 2, the possession of drug paraphernalia, to consider withhold of adjudication, preventing any collateral consequences to his license if he has one or has the intent on getting one in the future.
I'm not ranking. I'm just saying. I said you're right. I said you.
All right, sir. You want to resolve your case today? Would you like to resolve? Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, I do.
All right. It's my understanding you wish to waive your right to a trial, sir?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication?
Excuse me, ma'am.
Are you under the influence of any drugs or alcohol?
No.
How do you want to plead? Guilty, not guilty, or no contest to soliciting,
No contest.
hold on, to soliciting display on public right-of-way and possession of drug paraphernalia?
No contest, ma'am.
The court is going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Court's going to withhold on each count and impose court costs of $78 on count 1. Court will give him 6 months to pay. Court will take judicial notice of the time that he served in the Broward County Jail. You're done with this case, sir. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir.
Yes, ma'am. Thank you.
All right, so the next one is going to be Antonio Derrico, page 7. Good morning, Mr. Derrico. How are you?
Okay.
All right, sir. You have disorderly conduct, breach of the peace, $25 bond. Anybody want to be heard? Thank you.
Judge, I think Mr. Jericho, you wish to ask for you to consider resolving this case today.
Sure, State.
State's offered to be time served.
Okay, adjudication and time served.
who wishes to accept the state's offer.
All right, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, state your first and last name.
Antonio Joe.
Derico?
Yes, ma'am.
All right, you can put your hand down. It's my understanding you wish to waive your right to a trial, sir?
Yes, ma'am.
Are you doing this freely and voluntarily?
Yes, ma'am.
No one's forcing you to do this.
No, ma'am.
Okay, you under the influence of any alcohol or drugs?
No, ma'am.
All right, how do you want to plead to disorderly conduct, breach of the peace?
No contest.
The court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Adjudication, time served, $293 in court costs. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. And the court finds probable cause for the plea. Next one's going to be Todd Rose, page 8 of the docket. Yeah.
He's approaching drug use for investigation.
Okay. Okay, Mr. Rose, you have alcoholic beverage violation.
Yes.
Okay, you're drinking beer in the park, the beach park. Okay, you want to resolve your case today, or you want to fight your charges?
I'd like it resolved.
Okay, the court will adjudicate you and time serve you, but the court's going to tell you, sir, you can't go back to the park and drink and have an open container. Okay?
Yes, ma'am.
All right.
Yes, ma'am.
Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
All right. Put your hand down. Is your name Todd Rose, R-O-S-E?
Yes.
All right. You want to resolve your case today and give up your right to a trial?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness that would affect your ability to understand what's going on here today?
No.
How do you want to plead to alcoholic beverage violation, sir? Guilty, not guilty, or no contest? No contest?
No contest.
Court's going to accept your plea, find that's freely and voluntarily entered. The court's going to adjudicate you, time serve you, $78 in court costs. Court's going to find that the plea is freely and voluntarily entered. You have 30 days to appeal the sentence of the court, sir. Thank you.
Thank you.
Thank you. Next one is Gordon Hoysh, page 8 of the docket. Hello, Mr. Hoysh. How are you this morning?
I'm good. Good morning.
Good morning. All right, you are obstructing traffic on Southwest 2nd Street and South Andrews Avenue. State, do we have an offer for this case?
State's offer is time served.
He wishes to accept the state's offer.
All right, adjudication and time served. Raise your right hand, sir. Do you swear and/or affirm to tell the truth?
Yes.
All right, put your hand down. Gordon Ellsworth Hoysh, C-O-I-S-H is your name, sir?
Yes, ma'am.
All right, how do you want to plead to obstruction of highway? Guilty, not guilty, or no contest?
No contest.
Okay, the court's going to accept your plea. You understand what's going on here today, right?
Yes, ma'am.
You're not under the influence of any alcohol or drugs?
No.
And you don't want a trial, right?
No, ma'am.
All right, adjudication, time served, $293 in court costs. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Next one is Kyle Capretta, page 11 of the docket. Correct. Hello, Mr. Capretta. You have resisting arrest without violence, disorderly intox, and possession of drug paraphernalia.
Good morning, Your Honor. George Odom on behalf of Jara McLawrence, first seeking appointment to Mr. Capretta's case.
Hello, again.
Good morning. First request I'm going to make, Your Honor, is after reading through the fact pattern, I'm going to ask the court to transfer this, or at least preliminarily transfer it over to Judge Lerner Wren's courtroom.
Okay.
The second request I'm going to ask, in addition to reading the facts, although may raise an eyebrow or two concerning Mr. Capretta's state of mind, I don't think remaining incarcerated is going to assist in what he may need without going into the facts of the matter. So I would ask the court to consider, instead of the $100 bond that's on count one, to release him on his own recognizance.
If I transfer it to Judge Wren, I'm not gonna do that. Judge Wren wants a bond left in place. And I don't know, when can we get him in there? It's Wednesday.
Uh,
I'm
I
asking
could ch-
Mr., I'm sorry, Mr.
I don't know.
I mean, I could
I have
check
no
with
idea.
her.
Hold on, what?
I have no idea, Joe. I text her JA and they put the transfers on at the next available date they have.
Well, here's what I'll do, Judge. We will, since we now represent him, that's our responsibility to try to get him in front of, I still want him to be transferred over at this point, and we'll reach out to her JA to see if we can get him in front of her as soon as possible, hopefully maybe even Friday before the weekend hits.
Okay, bond's $98, thank you. On count one, the other two, I don't need to set bond. Next one. Oh, thank you. Next one's gonna be Omar Payret, page 14 of the docket, please. Omar Payret, please. Hello, sir.
Good morning.
Good morning. You have possession of cocaine, $1,000 bond. Count two is possession of drug paraphernalia. There's no bond attached to that. You do have a bond surrender on counts 3, 4, 5, and 6, which are not for magistrate court. Those bonds are, just so you know, $25. Let's see. It appears the writing's very small. 25, 500, 500, 500. So it appears to be $1,525. Does anybody have an objection to probable cause?
No, Judge. Except I would point out, it does appear as though the cocaine involved in this case is a residue amount. So ultimately, I would imagine the state will be filing this charge as a misdemeanor drug paraphernalia charge. I'd ask the court to take that into consideration when setting bond on count one.
Okay. All right, so give me a suggestion as to bond, state.
Just to advise the court, Mr. Payret was arrested on a trespass a couple weeks ago. At that time, he was also picked up on a capias on a misdemeanor case for resisting without violence, theft, and trespass. He bonded out on all those charges, total of just over $1,500. He's been through this division many times for prior arrests and prior failures to appear.
All right, so court's gonna leave the bond at $1,000 on count one. Thank you. Next one is George Davis, page 14 of the docket, please.
Mr. George Davis, as private counsel, Mr. Joshua Mendez.
Could the court just confirm if that's for all, for?
Go ahead, you can inquire.
Hey, good morning, Mr. Davis. My name is George Odom. How you doing this morning? I heard Mr. Romero there, who was to your right, said you have private counsel. I just want to be clear for the record. I know you have a felony count here on count one. You also have 2 city municipal ordinance cases that you're currently have pending as well. Will your private counsel be representing you on those 2 cases as well?
Yes.
Okay, thank you. That's all I have, Judge.
All right, so let's not do the order on Davis. All right, sir, what is your attorney's name?
Joshua Mendez.
Spell the last name.
I think it's M-I-G-E-L, something like that.
Yeah, I tried to find him in the Florida Bar Journal, Judge, with no success.
All right, let me ask you this. Did he represent you previously?
Yes, ma'am.
Okay, and where did he represent you previously? In a Broward County case, or was it a Dade or Palm Beach?
Broward County.
It's Josh Rydell.
Josh Rydell?
Yes.
All right, is there any way someone could call Mr. Rydell?
As long as he's not going by the AKA of Joshua Mendez, I'd be glad to call Mr. Rydell.
Okay. All right, sir, we're gonna recall your case for your attorney, okay?
Okay.
Have a seat. We'll try to get a hold of him so he can represent you. one is going to be Mark Iser, page 18 of the docket. Mr. Odom, this is this is the city of Pompano, okay. All right, Mr. Iser, is that how you say your name, sir? Weiser, I'm sorry. You have a municipal ordinance, open container, and you do have 2 probation violations. Community control, you are gonna be held no bond. You are gonna go before your division judge, Judge Joffrey Cohen, on May 7th, which is a week from this Monday, at 9:45 a.m. Would you like me to do anything on the municipal ordinance bond, Mr. Romero? I can't hear you, you turned it off.
I have nothing to say on the municipal one, Judge.
Okay, $24 bond. Thank you.
Thank you.
Next one is going to be Ryan Quimet on page 21 of the docket, please. We have a warrant to arrest that was provided by the state. Okay, good morning, Mr. Quimet.
Decline the services of public defender?
All right, sir, do you have a private attorney?
Yes, ma'am.
Okay, what's your private attorney's name?
Michael Gottlieb?
Does he know you're here today?
I don't believe so.
All right, sir, let's get a hold of Mr. Gottlieb, or see if we can. Do you have his number?
Okay. I was supposed to be today to negotiate my surrender with the detectives, but I got a speak too much.
All right, so hold on. What is it?
I'm texting them.
You are?
I know. Calm down. I'm just telling the judge. I'm texting them, Judge.
All right, sir, have a seat. We'll recall your case. We're trying to get a hold of your attorney, okay?
Okay, thank you.
You're welcome. All right, next one is going to be Malcolm Robinson.
Mr. Robinson's here on main, Judge, and he advised me that he has private counsel, Mr. David Solomon.
Does anybody have Mr. Solomon's number, or do I need to look it up?
I can get it. It is.
You want to call, text him, or?
I don't know that I can text him. I don't have a cell. I just have the number he listed in his notice of appearance.
All right, so Mr. Reedy, would you do the court the favor of calling up David Solomon and tell him?
I've already left a message for Mr. Solomon, Your Honor. His secretary is getting in touch with him, and they will call me back shortly.
All right, sir, have a seat. We'll recall your case. We're trying to get a hold of your attorney, okay? All right, so that's the end of the special list. And then,
Judge, I've been advised by the deputy, there's one more on that list. Page 8 of the document, his name was Mr. Alexander Peasley.
is he on this list? Okay.
Is it a misdemeanor?
Is it a misdemeanor or a felony?
It was a misdemeanor.
Okay, give me one moment. Are you Mr. Peasley?
Page 8. Page 8.
Are you Mr. Peasley?
Good morning.
Good morning. What's your last name, sir?
Peasley, P-A-S-L-E-Y.
Okay. Okay, Mr. Peasley, you are charged with resisting an officer or obstructing without violence. Court does find probable cause, bond set at $100. Anybody want to be heard?
Mr. Peasley wishes to ask the court to consider resolving this case today for the crime to the judge.
state. Raise your right hand. Do you swear and/or affirm to tell the truth?
I do.
All right, put your hand down. Is your name Alexander Peasley, Peasley? Is that how you spell your name, sir?
Yes, ma'am.
It's my understanding you wish to waive your right to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to discharge could result in deportation proceedings against you and affect your ability to remain in the United States?
Yes, ma'am.
Okay.
Your Honor, the state's offered being adjudication time served. He has priors out of the state of Maryland.
Okay. Hey, understanding what I just explained to you, are you pleading guilty, not guilty, or no contest to resisting an officer obstructing without violence?
No contest.
The court is going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file, finds probable cause for the plea. The court's going to adjudicate you, time serve you, $293 in court costs. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you. Next one is Terrence Gerard Walker. What page is that, Mr. Odom?
7 of the document, Your Honor.
Thank you. Okay, good morning. How are you? All right, you're Terrence Walker, sir?
Yes, ma'am.
All right, we have Mr. Odom here, who's representing you from Mr. McLawrence's office.
Good morning, Your Honor. George Odom on behalf, as you stated, of Mr. McLawrence. Mr. Walker, let me ask you this question. Are you open to resolving your case today?
Yes, sir.
Judge, I would ask the court, it appears that he had been, according to the PC, trespass warned a couple times, not getting to any admissions. I know the officer stated that he advised he had been warned at least once and then returned. This appears to, I believe, be a store located on 1249 West Sunrise Boulevard. Yes. No, actually, I think it's the convenience store across the street from the AutoZone, if I'm not mistaken. I think he was.
Correct, he walked across the street south across to the AutoZone. Okay.
So what I'd ask the court just consider is a adjudication, time served, and of course a no return to 1249 West Sunrise Boulevard, Fort Lauderdale, Florida, 33311.
Yes. Yes, but I want to remind you, anything you say can and will be used against you, so don't talk about the facts of your case. You can talk to Mr. Odom, I'll allow you to talk to him, but privately.
You need to talk to me briefly in private? You can, just, if you want to ask me a question or something to that effect of what you may need to reference in this case, we can do that. Just put you on recall.
All right, let's recall him so you can talk to him, okay?
Thank you, Judge.
You're welcome. All right, so let's go to Novetta Sargent, please. Novicia Sargent.
North Broward.
She's in North Broward, Judge.
Okay, North Broward, do you have Ms. Sargent? Hello, ma'am, good morning, how are you? You are charged of touch and strike battery. Any objection to probable cause defense?
On Ms. Sargent, no, Judge, but I would be asking the court to consider placing her on pretrial release. She has been living here all of her life. I don't believe she has an extensive criminal history. She can stay with her sister, where she's been living for the past year, and I think she'd be a good candidate for pretrial release on this. She's not going to be able to post any kind of a monetary bond on this matter.
Your Honor.
Hey, ma'am, the court's going to order no victim contact, direct or indirect, with the alleged victim with the initials RAL. And anybody that can hear me, I want you to listen up. No contact, direct or indirect, means no contact in person, calling, texting, writing, nothing on social media, even liking, disliking anything, and no contact through third parties. Do you understand, ma'am? All right, state?
State would be objecting pretrial, Your Honor. She was arrested last December on a violation of pretrial on a possession of PVP and possession of cocaine case. In that matter, she removed a GPS monitor. Pretrial had no idea where she was. The GPS monitor was found in a garbage can.
Well, as I say, Judge, I mean, I don't know exactly what happened here. There are two sides to every story on this battery charge. But if you don't put her on pretrial release, she's not going to be able to make any kind of monetary bond. She'll sit in jail.
Right.
She
Well,
can
that's
provide you
about
with the address.
GPS monitor. So, no victim contact, $1,000 bond, and I am putting her on pretrial release as well. Thank you, ma'am. Thank you. Juan Garcia, 1,000 and pretrial release.
Judge, did you call Erica Tillman?
Is that one of the ones on our list?
No.
Why should I have called that one then?
I don't have your list. I only have the list from the main jail.
That's my
Erica
list.
Tillman
Okay.
was supposed to be the first one on.
Yeah, she's the first one on the docket.
Well, I don't know
Maybe she
where
got
she
mixed
is,
out
so
of order. Timing.
the paperwork is all mixed up, so. Who is this?
This is Erica Tillman, Your Honor.
All right, you know what? Let's just have her sit down and let me just go through it straight. Yeah, I don't know what happened to it. All right, Juan Garcia. I don't know what page that is or where it is. Is that one of the ones you
Your
pulled?
Honor.
Okay,
And he also has a state misdemeanor charges as well.
I have no idea.
Page 9.
Mr. Odom pulled him out of turn. All right, Mr. Garcia, good morning, sir. You have count 1, DUI, alcohol or drugs, first offense, $500 bond. Count 2, DUI and unlawful blood alcohol level above a .15, $1,000 bond. Count 3 is DUI with damage to property or person of another, $1,000 bond. Count 4 is operating without a valid DL, $25 bond. You do have a capious traffic, $1,000 bond, capious misdemeanor, $50 bond. And you have a civil infraction, count 7, vehicle without lights at night. It's actually not for magistrate court, that's just a regular traffic ticket. You are going to your division judge May 4th, which is this Friday, in Division MW, who is Judge Cal Evans. Any objection to probable cause?
No.
Okay. Mr. Reedy, I know your client said no, but,
No, I have no objection. I agree with my client, Your Honor.
okay, that's good. Okay, Mr. Odom, any objection to probable cause on your MO case?
No, Your Honor, it's my understanding it's a capious PC was previously established and bond has already been set, so I have no formal position.
Okay, all right, so anybody want to be heard with regard to the bonds?
Judge, and speaking to Mr. Garcia, he did give me the phone number to his friend.
Okay,
I will be contacting him after court, and he says his friend should have no problem posting the bond.
all right, if there's a problem, put it back on, okay? All right, sir, I just want to inform you, this Friday, you have to go before Judge Cal Evans, otherwise you'll have a warrant for your arrest. All right, and that's at 9 a.m. here in the new part of the courthouse, Judge Cal Evans. You might want to write it down for him. Mr. Romero.
Let me get a sheet of paper. Hold on 1 second, Judge, so we don't.
7.
You see if I can find his paperwork. over
Oh,
here.
no worries. Hopefully you didn't put it. It's a
We're gonna
recall.
Walker, yeah. Judge Cal Evans. He's the 6th floor, oh no, he's the 5th floor. So on the same floor as, I don't know the courtroom number, no. All right, Mr. Odom wants me to call Terrence Gerard Walker. Where is he, North Broward? Was I correct? or-
Yes.
Yes, okay. All right, welcome back, Mr. Walker. How are you?
Good.
All right, you had enough of time to speak to Mr. Odom?
Yes, ma'am.
All right, so what are we doing with this?
We're looking to resolve judge adjudication time served. The court is inclined to do so. And no return to the address listed previously on the record.
All right, sir, you want to resolve your case today?
Yes, ma'am.
Raise your right hand. Do you swear and/or affirm to tell the truth? All right, put your hand down. Is your name Terrence Walker, sir? W-A-L-K-E-R?
K-E-R.
Okay.
W-A-L-K-E-R.
Okay. It's my understanding you wish to waive your right to a trial, right? Yes? No?
Yes, yes,
Anybody forcing you to do this?
no,
Are you under the influence of any alcohol, drugs, or medication?
no,
Ever been treated for a mental illness?
no,
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States? Mr. Odom, help me out.
The question was, do you understand that if you are not a United States citizen,
Born in Fort Lauderdale. You can ask him anyone.
the question is, do you understand that if you are not a United States citizen, that resolving this case, some say may, I say will, result in you being deported from this great country? Do you understand that?
yes,
Do you still want to resolve your case today understanding that?
yes,
All right, how do you want to plead? Guilty, not guilty, or no contest to trespass after warning?
no, no contact.
You're not going to go back to 1249 West Sunrise Boulevard, Fort Lauderdale, are you, sir?
No, ma'am.
You agree to stay away from there?
Yes, ma'am.
You understand that if you go back there, you're going to get arrested and come back again.
No, ma'am, I will not go back, ma'am. I will stay away from there.
All right, the court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Adjudication time served, $78 in court costs. You have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. No return, sir. 1249 West Sunrise Boulevard, Fort Lauderdale, Florida. Thank you. Good luck to you.
Thank you, Your Honor.
Anybody else, Mr. Odom? We're done?
Judge, I have one that was a medical reset from yesterday, Mr. Quinn, who's on page 12 of your docket. Okay.
Darius Lamar Quinn.
No problem.
George Odom standing in on behalf of Mr. McLawrence. I have no this is not standing capious. So PC had previously been established and bond has been set. I'm just looking to get him in front of the division judge at this point.
Okay, so you don't want to resolve this case, possession of drug paraphernalia?
It's his decision. I wouldn't recommend it based on the probable cause, the facts and the probable cause. I think he has a good legal argument to make concerning the stop.
No problem.
However, it's not my choice, it's his, if the court would allow me to ask him. Mr. Quinn, how you doing this morning?
I'm all right.
Okay, you've heard what I said. I would recommend you not resolve today. However, it would require you to remain in custody, and you would need to go in front of your division judge for us to filter out any potential legal arguments you may have. The alternative, if the court is inclined to do so, and this...
Well, I would like to resolve it today.
Oh.
I was asked on the phone earlier if I would like to resolve it. I was
Right.
like, yeah.
Okay, I just wanted to make sure you understand, so you do want to resolve your case today?
Yes, sir.
Okay, would the court be inclined to do
Yes.
a
Raise your
withheld?
right hand. You swear and/or affirm to tell the truth?
Yes, ma'am.
All right, is your name Darius Lamar Quinn, Q-U-I-N-N?
Yes, ma'am.
All right, no one's forcing you to do this, right?
No, ma'am.
Want to give up your right to a trial?
Yes, ma'am.
And you want to plead guilty, not guilty, no contest to,
contest.
hold on, possession of drug paraphernalia.
No contact.
Ever been treated for a mental illness?
No, ma'am.
All right, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Withholding court costs, court takes judicial notice of the time that he served in the Broward County Jail, $78 in court costs. You have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. Good luck to you. You're done with this case, sir, except for paying your court costs of $78. Thank you.
You're welcome, ma'am.
Thank you, Mr.
May I
Odom.
be
Have a
excused?
great day.
Thank you, Judge.
All right, Randy Ruane, R-U-A-N-E. Hello, ma'am, how are you? All right, ma'am, you have petty theft, second degree, first offense. Court does find probable cause. Ma'am, you're not to return to the Publix located at 2511 East Atlantic Boulevard. You understand?
Yes, ma'am, I do.
You understand that if you do return there, you're gonna be arrested again just for going there.
Yes, ma'am, I understand that.
All right. Bond is set at $25. What are we doing, Mr. Romero? Sure. Okay,
State's offer to be time served, no return to the Publix at 2511 East Atlantic Boulevard in Pompano Beach.
all right, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right. All right, you said withhold or adjudication, I'm sorry.
Adjudication.
Is that what you want to do, an adjudication in time served, Mr. Romero?
Let me talk to her for the consequence, Judge.
Sure. Well, you can ask, okay.
She said what you proceed for, Judge.
All right. All right, ma'am, it's my understanding you wish to waive your right to a trial in this case?
Yes, ma'am.
Anybody forcing you to do this?
No,
Are you under the influence of any drugs or alcohol?
absolutely not.
Ever been treated for a mental illness?
No.
Are you on any medications?
Yes, I take prescription potassium.
Okay. Does your potassium obviously doesn't affect your ability to understand what's going on here today?
No, and not at all.
Okay, Mr. Romero, you may inquire with questions regarding if she gets her third arrest for petty theft, sir. I'll let you inquire.
Okay, you do understand that President Park for possible consequence in resolving this case to an adjudication, is that correct? And I did advise you on the circumstances the state has gotten as far as charging you like a felon. Understand? And they can use this as an enhancement for future charges if you get arrested on a subsequent theft offense.
Yes, I understand.
All right, understanding what Mr. Romero and I just explained to you, are you pleading guilty, not guilty, or no contest to petty theft, second degree, first offense?
Guilty.
Okay, the court's gonna accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Adjudication, time served, $293 in court costs, no return to the Publix, ma'am, at 2511 East Atlantic Boulevard, Pompano Beach, Florida. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you.
Thank you.
All right, well, let's take,
North Broward has one they would like you to call, Judge. There's a
all right,
medical issue.
I'm trying to get one, there's family here from Mr. Gonzalez. So let me just,
Does he need a Spanish interpreter? Yeah, he's gonna need a Spanish interpreter, Judge, and there's one on the way.
anybody you know that needs a Spanish interpreter there, Mr. Romero? I can pull them out now.
Judge, I know on page 9, Mr. Morales prefers Spanish interpreter, more comfortable
That's fine.
speaking Spanish, and I believe there were other individuals that both could understand English, but they would feel more comfortable using Spanish interpreter. On page 9, Mr. Gonzalez, and I'm trying to find the page.
I pulled that out, I pulled that out. So is it Edwin Morales Hernandez?
That is correct, Judge.
All right, nobody else, right?
And on page 8,
Okay,
Mr. Fajardo on page 8, Judge.
spell that.
Fajardo.
That's after Morales, right?
Mr. Morales was on page. Morales was on page 9, so before Morales,
Okay,
Mr. Fajardo.
all right, thank you. Okay, I have him, all right. All right, so I have the Spanish here. We'll wait for the Spanish interpreter. All right, so which one did North Broward, which one did you want me to take out of turn? Page 3.
Naomi,
I morning, ma'am. How are you? Okay. All
Ms.
right.
Ms. Rucker would like to know if it's possible to resolve this case. I advise Ms. Rucker that 3 driving while suspended license charges can result in a lengthy driver's license suspension of 5 years.
She's charged as a felony. You can't resolve it.
Oh, it is a felony. She's already habitual. That's true. I didn't realize that. Sorry, Judge. I would ask the court to consider pretrial release from Ms. Rucker then.
Sorry, what'd you say?
I'd ask the court to consider pretrial release from Ms. Rucker.
State?
One moment, Judge.
Okay, state pretrial release.
One moment, Judge.
Ma'am, is your address
Just
4701
failures to
Southwest
appear.
23rd Terrace, Fort Lauderdale?
Just not failures to appear on file.
All right.
I've also been in touch with her family, Judge, and she has strong family ties to the community. I spoke with her sister this morning.
6, 7, 8, 9.
Ma'am, you understand you can't drive until you get a valid license, okay?
Your Honor, I'm opposing pretrial. I'm looking at her driving record. Her license has been suspended on at least 12 occasions for failing to appear in court.
Well, I did speak with Miss Rucker's sister. I don't know that she's going to be able to make the $750 bond, Judge. She's calling other relatives to see if that can be done.
All right,
So-
let me look. Since 2011, failure to appear, 1, 2, 3, 4, 5, 6, 7, 8. Hold on.
Well, hold on. Don't say
9,
anything,
10,
Miss
11,
Rucker.
12, 13, 14, 15,
Yes, more.
16, 17, 18. I'm not putting her on pretrial release. So what would you like to do, Mr. Romero? I mean, Mr. Reed, I'm sorry.
Judge, I'd ask you to reduce the bond to $250.
Okay, court's gonna reduce the bond to $500. Thank you. No driving, ma'am.
I'll call your sister back, and hopefully she can come get you, okay, Miss Rucker?
Caitlin Leah Williams, please. Caitlin Leah Williams, is she at the main jail?
Oh, she's in North Broward, Judge.
Okay. Did we ever hear back from those private attorneys?
I heard back from one, but not the others.
Okay. Good morning, ma'am. How are you?
Very well, how are you?
Good. All right, ma'am, you have 2 capious misdemeanors, $500 bond, $500 bond. They're both for, one's operating without a valid license, and the other one is driving while license is suspended. What are we doing with these?
Judge, I'd ask you to consider pretrial release from Miss Williams based on the nature of these charges and her ties to the community. She's been living here a long time. And she does have a friend that I called earlier this morning who indicates to me that she will be coming back to court. She does have a place to stay.
He's got a copy of the warrant. Your Honor, the state would be opposing release to pretrial. One, she's here because she failed to appear in these cases. 2, she does have an open trafficking in oxycodone and 2 counts of delivery of oxycodone. Your Honor, I can tell the court the offers that her ASAs on these cases were prepared to give were withhold and court costs, and I would relay those offers as well. It would be a second DWS, but it does not.
She has a pending felony.
She does have a pending felony, Your Honor. These would add 0.2 points if she pled them out to her her felony.
Defense? We gotta let Mr. Reedy hear that.
Yes, Judge. I understand. I know. I'm aware of Miss Williams' situation, Judge.
They're offering her a withhold and court costs that'll add 0.2 to
I think it might be in her best interest to resolve the case.
these 2 withholds.
Yes.
to withhold?
And Brian, it would be a second DWS. It does not appear it would be a third.
I explained to Ms. Williams that if she continues to pile these charges up, she's going to get a lengthy driver's license suspension and possibly a felony charge as well on this. Ms. Williams, I can get you out, withheld adjudication, no conviction on your record. Is that what you want to do?
Yes.
Okay. All right. I called Casa. I spoke with him. So I'll let him know what happens, okay?
Okay, so I don't need to post bail?
That's right. The case will be over today.
Okay.
This case will be over.
This case will be over.
All right, ma'am, let me tell you something else. I'm looking at your driving history. You know, if you go to browardclerk.org, they have clinics where you can go to, and you can enter into a payment plan for your tickets, and then you'll get your driver's license back. But you gotta make the payments.
That's part of the reason I haven't gotten it back is because of the financial situation, you know, I'm still paying off my current.
Well, they're having one, I think, soon. I'm not sure. You really might wanna look into it, okay? All right,
Okay,
wait,
yeah,
go
I
ahead.
would love to do that. I would love to do that. I just, like I said, the financial situation is kind of, you know, tough right now. I'm still paying off my first bondsman and stuff like that, so, and because of the previous charge, I lost my apartment and a place to live and everything like that, so things have been kind of hectic, but, I would be open to doing that, you know.
All right, you gotta go to browardclerk.org and, ask them, Madam Clerk, can people enter into a payment plan anyway for a ticket? Or you can request an extension from the judge that, you know, imposed it, ask him for more time to pay possibly. Anyway, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Is your name Caitlin Leah Williams, WILLIAMS?
Yes, Caitlin Lee Williams.
Okay, it's my understanding you wish to waive your right to a trial in both these cases?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Do you have enough of time to speak to Mr. Reedy about accepting a plea in this case?
Yes, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Are you on any medications?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States?
Yes, ma'am.
All right, you know, if you get 3 convictions of driving while license is suspended within 5-year period, the Driver's License Bureau is going to revoke your license, and you're going to be a habitual traffic offender.
Okay.
All right, and your license gets suspended for 5 years. If you're caught driving, they can charge you as a felony. Do you understand?
Yes, ma'am.
All right, understanding what I just explained to you, you pleading guilty, not guilty, or no contest to driving while licenses is, hold on. How do you plead? Guilty, not guilty, no contest to operating without a valid license and to driving while license is suspended.
No contest.
The court is going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Court is going to withhold adjudication and impose court costs in each case of $293. The court will give you 6 months on one case to pay and $293 on the other. The court will give you 1 year to pay. The court will also give you the option of doing community service hours at the rate of $10 per hour.
Your Honor, that would not include cost of prosecution?
No, it will, because just show me case law or some statute saying I can't do it, and I'll be more than happy to talk about it.
Yes, Your Honor, one moment. And if, Your Honor, I'm gonna find the statute, and actually the statute covers the entire cost, not just cost of prosecution.
All right, so what we'll do, ma'am, we'll recall this case because we got to get moving with the docket and the Spanish interpreter, and we'll deal with this in just a little bit, okay?
Okay, so you're gonna call me back up?
Yes, ma'am. Thank you.
Okay.
All right, you're welcome. All right, sir, which case are you here on?
Page 21, Ryan Wimet, Mike Gottlieb on his behalf. The case is, I believe, called but not addressed this morning.
I'm sorry, the last name?
Ouimet, page 21. Ryan Anthony Wimet.
Okay. Sorry, it was stuck
Judge, I've had an opportunity to review the probable cause affidavit, which in this case is a warrant.
All right, let me just get your client, hold on.
Oh, okay, I'm sorry.
That's okay. Are you Ryan Anthony Omet? Okay, hit the button, sir, so we can hear you.
Yes, ma'am.
All right, thank you. Let me just tell him what he's charged with. Sir, we have count 1, burglary of an unoccupied dwelling unarmed. We need to talk about bond. Count 2 is, unless this is a warrant, count 2 is petty theft, second degree, first offense. All right, go ahead, counselor, I'm sorry.
Judge, I don't really take issue with probable cause, but I think something that the court should take into consideration is the way the identification was made was a single photo identification off of Facebook, which leads to the identification of Mr. Wimet, which leads to the pawn shop. So I do think that there is potentially a Fourth Amendment violation. I'd like the court to take that into consideration when setting a bond as well. Mr. Wimet had been out of state before he knew that he was wanted. He was out of state. He's been speaking to me over the weekend. He just got into town yesterday, had a meeting with me, and I told him we were going to surrender. I would only represent him if he surrendered. He said he would. He never made it to my office because he got picked up. I wasn't even aware. I didn't realize he got picked up until I got a call this morning. So respectfully, I don't believe him to be a flight risk. I understand there's probable cause. I would ask the court to view the case in the light that I've just explained in terms of the possible Fourth Amendment violation and his willingness to surrender, and set a reasonable bond, pretrial release if the court deems necessary. And I didn't have a chance to get family members together, but I was contacted by family and friends to represent him, so I know he has ties to the community as well, Judge.
All right. State.
Well, Your Honor, first off, I don't believe there are any Fourth Amendment concerns, noting that one of the witnesses who identified Mr. Wimet is a woman that has children with his brother and has known him for 10 years, and identified him from surveillance video taken by the victim's own surveillance video in her home. So even despite any of the other identifications, that identification in and of itself, I don't believe violates. No, I'm just rebutting the.
What are you requesting today? I understand what you're doing.
Your Honor, the state is requesting a $20,000 bond. My concern regarding Mr. Wimet is safety of the community, and it is based on not only the allegations in this case that he broke into someone's home, but his criminal history. 2010, 2 counts of uttering a forged instrument and grand theft. He violated probation and was sentenced to 5-year state prison. 2010, uttering a forged instrument and grand theft. Violation of probation, 5-year state prison. 2010, dealing in stolen property, violation of probation, 5-year state prison. 2010, dealing in stolen property, false ownership info on a pawn item, violation of probation, 5-year state prison. 09, uttering a forged instrument, violation of probation, 5-year state prison. 2010, false ownership info on a pawn item, VOP, 5 years. 09, grand theft, VOP, 5-year state prison. He was released from state prison just over 2 years prior to this alleged burglary.
Staying on count 2.
Your Honor, it's a misdemeanor theft, whatever the court imposes.
It actually says NB, no bond. Is that what
Judge
that
Rothschild
says?
put it at no bond on the warrant, but it is a misdemeanor.
Okay,
No further argument, Judge.
okay. All right, so this is what the court's gonna do. The court is gonna do a $20,000 bond on one. Court will do a $100 bond on, I'm sorry, 20,000 on one, $100 on count 2, no victim contact, direct or indirect, with the alleged victim in the case with the initials C, M, and MM. That means no contact in person, calling, texting, writing, or through third parties. Of course, that doesn't include you, Mr. Gottlieb. Court is gonna order you no return to 9471 Southwest 49th Street, Cooper City. Court is gonna put him on a GPS level 2. Thank you very much, Mr. Gottlieb. Have a
Right,
good
Judge,
day.
thank you, you too.
And Your Honor, just the record, the alleged victim's initials are CH and MH.
Oh, I thought it was CM. Just look. Oh, it's CH and MH. Okay, so sir, the alleged victim is not CM, it's CH and MH. Do you understand?
Yes, ma'am.
All right, and you're to maintain 1,000 feet from this Southwest 49th Street.
Yes, ma'am.
Thank you very much, sir. Good luck to you.
Thanks, Judge.
okay?
Have a nice day.
All right,
And,
thank you, sir.
Your Honor, we can go back to Caitlin Williams' case.
Yes,
I believe she's at North.
yes.
Your Honor, I would direct the court's attention to Florida Statute 938.27.
What I was saying is I want to recall this at the end
Oh, okay, I
so
didn't,
we can go over it.
that's fine.
I just want to continue on with the docket.
Okay.
All right, we're gonna recall you, ma'am.
Okay,
All right?
sorry.
I appreciate, no, that's okay. I appreciate your patience. All right, Eric Sherry Tillman, please. Eric Sherry Tillman.
She's in North Broward, Judge.
Oh, we have the Spanish interpreter here. We'll get to you right after this one. I'm sorry. All right, Ms. Tillman, good morning, ma'am. Can you hear me?
Yes.
All right, ma'am, you have trespassed a structure or conveyance. You failed to appear in court or failure to comply with conditional release plan in front of Judge Wren. You have a no bond hold. You are going before your division judge on May 10th, which is a week from today, at 2 p.m. You're going to be held no bond pending that hearing per Judge Wren's order. Okay, ma'am? Good luck to you.
Judge, is there any way we could possibly move that court date up?
You're going to have to contact Ms. Wren's office. I mean,
All
Judge
right.
Wren's office.
And Ms. Tillman did indicate to me, Judge, and I'm sure that they have a meal waiting for her after court, but she did indicate that she was very hungry.
Okay. Deputy? Have they been, is there a problem with meal times?
No, I don't think so. I just think some people get hungry at different times, Judge.
All right, Deputy, Mr. Reedy is telling me that
Ms. Tillman is hungry,
Ms.
Deputy.
Tillman is hungry. All right.
Can we get her some food, Deputy? Okay, thanks so much.
Jordan,
All right, good luck,
Matt,
Ms.
please.
Tillman.
Oh, hold on. Let's call the Spanish interpreter. I'm sorry, I keep forgetting. Come on up. How are you? Just wave at me sometimes when I forget, okay? Thank you. Do you swear and/or affirm to tell the truth, to translate from Spanish to English, English to Spanish to the best of your ability?
Maria Salazar, Certified Court Interpreter.
All right, spell your last name.
Salazar.
All right, thank you very much.
You're welcome.
All right, so let's call a couple cases at a turn, and then Mr. Rydell will get to you.
Thanks, Judge.
Peru Fajardo.
Senor Fajardo. He's approaching the hearing.
All right, are you Mr. Fajardo?
¿Usted es el señor Fajardo?
Sí, señorita.
Yes, ma'am.
All right, good morning, sir. You have operating without a valid license.
Señor, buenos días. Se le acusa de operar o manejar un automóvil sin licencia válida.
$25 bond.
La fianza serían $25.
And you have a warrant for operating without a valid license, $500 bond.
Señor, también tiene una orden de arresto por manejar sin licencia válida. Esas serían $500 de fianza.
Court does find probable cause.
La Corte encuentra que hay causa probable.
Total bond is $525.
La fianza total serían $525.
This is going to be scheduled in Division MS.
Se lo van a poner para que vaya a la división MS.
In the division, there's not a date yet. I don't know why.
No han puesto fecha para la división, no se sabe por qué.
Or actually, it's MD. It's Mindy Solomon.
De hecho, es la jueza Mindy Solomon.
All right, so what does he want to do, Mr. Romero?
¿Qué es lo que usted quiere hacer, señor?
Judge, Mr. Fajardo gave me the phone number of his friend when he's been calling him. He said he'd be able to take his file back.
Su abogado dice de que ha llamado a una persona que va a poderle poner la fianza.
Okay, is his address 1441 Lee Street, Hollywood?
Su dirección es 1441 East Street en Hollywood.
Sí, señorita.
Yes, ma'am.
All right, make sure you look out for your court date, sir. You don't want another capias and forfeit your $500 bond.
Asegúrese usted de cumplir con lo de la fecha para que reaparezca, porque si no va a ser $500 de fianza.
Thank you, sir. Good luck to you.
Gracias, señor. Buena suerte.
Edwin Morales Hernandez, please.
Mr. Morales?
Okay, Mr. Morales, sir, you're charged with one count of DUI, alcohol or drugs. First offense, $500 bond.
Señor, se le acusa de manejar bajo la influencia ya sea de drogas o alcohol. Son $500 de fianza.
Count two is DUI with an unlawful blood alcohol level greater than a .15, sir.
Señor, y el segundo cargo es manejar bajo la influencia y ha tenido al soplar ha salido con .015 de nivel de alcohol en la sangre.
Okay, so it's $500 bond on one, $1,000 bond on two.
Señor, serían $500 de fianza en el primer cargo, $1,000 en el segundo.
Count three is the unlawful speed, no bond attached to that.
Y en el tercer cargo le acusan de ir a velocidad no de acuerdo con la ley. Y entonces no le están poniendo fianza en ese tercer cargo.
You heard Mr. Romero with regard to bond or probable cause. Mr. Reedy?
Sorry,
Encuentran
Judge.
que hay causa probable para las acusaciones.
I said, do you wish to be heard with regard to probable cause and for Mr. Romero?
No, Your Honor.
Heard with regard to bond.
No argument regarding probable cause, Judge.
El abogado no encuentra causa, no va a hacer ningún argumento sobre la causa probable de su caso.
Judge, we're going to be asking the court to consider releasing Mr. Morales on pretrial release. I'll see if the state has an objection to that.
Su abogado está pidiendo que la jueza le dé la libertad a usted con el programa pre-trial.
I do not. I just ask no alcohol intoxicants.
No objection to that, Judge.
Okay, ROR on count one.
Está bajo
ROR on
palabra
count two.
en el primer
Standard
cargo.
pretrial release, no alcohol or intoxicants.
En el primer cargo, libertad bajo palabra. En el segundo cargo, también libertad bajo palabra con el programa pre-trial y la prohibición de que usted consuma drogas o alcohol.
Prescription medication is allowed.
Se le permite consumir sus medicinas recetadas.
All right, thank you, sir. Good luck to you.
Le agradezco, señor, muy buena suerte.
And then the next one for the Spanish interpreter is Oral B. Gonzalez.
Mr. Gonzalez has family members present, Your Honor.
Sure, that's page 17 of the docket. Come on up. Do we have Oral B. Gonzalez, Mr. Romero? Page 17.
We're trying to, right now he's got picked up on one second, we're trying to find him.
Okay, ma'am, state your name.
Juliana Gonzalez.
Okay, and your relationship to Mr. Gonzalez?
This is my father.
All right. And who's behind you there? Sir, if you could state your name, please.
My name is Ivor Taylor, Your Honor.
Thank you. And it's Taylor?
Taylor, correct.
And your relationship to Mr. Gonzalez?
He is my father-in-law.
Okay. Okay. Shortly, in how long? Should we do another case in between, or should we wait?
I'm looking for guidance. It's gonna be about a good 2 minutes, Judge, so you can make the call.
All right, let's call one case. Let's just have a seat right there, and he'll be here in one moment, okay? Jordan Mack, please.
Mr. Mack? Mack. He's approaching, Judge.
All right, good morning, Mr. Mack. How are you?
Good morning, Your Honor.
You have an ad charge for grand theft in the 3rd degree.
Hey, what's your name?
Yeah.
It's not.
Who's Jordan Mack?
It's a female.
Jordan Mack.
Jordan Mack is in North Broward, Judge. She's
All right.
she's in North Broward. She's got count 23 this morning.
She's in courtroom 7780.
That's what it says on the docket anyway.
All right, so Willie, here you go. She's in 7780. We'll reset for the PM. Madam Clerk, Willie will give you that in a moment. No, he needs that just for a second, so he can call up. All right.
Mr. Gonzalez is here, Judge.
All right, let's take his case, sorry. Come on back up, everybody.
May I keep recording? Mr. Gonzalez?
Hello.
Hi.
Okay, sir, do you wish to, let's have a Spanish interpreter? Are you Oral
He
B?
understands a little bit of English, Judge, but he feels more comfortable with Spanish, Judge.
That's fine. Okay, Mr. Oral B. Gonzalez, you have family members here.
Señor González, usted tiene sus familiares acá.
Can you see them, sir?
¿Los puede ver por la pantalla?
Hey, I see. My daughter.
Okay,
Oh, right. ¿Verdad?
okay. All right, so you have count 1, sir, aggravated battery with a deadly weapon. We need to talk about bond.
Señor, el primer cargo es agresión con agravante con arma mortal. Tenemos que hablar de eso.
And then we have count 2, battery caused bodily harm.
Señor, el segundo cargo es agresión física con gran daño corporal.
Bond is set at $1,000.
$1,000 es la fianza.
Any objection to probable cause, Mr. Reedy?
This appears to be a mutual combat situation, Your Honor.
Este incidente parece ser un incidente de combate mutuo, pelea mutua.
It's my understanding that both these gentlemen have a bit of a history.
Y el abogado que lo representa dice que parece ser que usted y ese otro señor tienen una historial de estar peleando.
Which unfortunately came to a head
Que desafortunadamente llegó a una situación
yesterday.
ayer.
Judge, it's my understanding Mr. Gonzalez has no criminal history.
Y entiende el abogado que usted, señor González, no tiene antecedentes penales.
I've spoken with his family here this morning.
Ya él habló con su familia hoy en la mañana.
They are very supportive of him.
y lo van a apoyar, están dispuestos a apoyarlo.
He's been living at the same address for a very long time.
Y que usted está viviendo en la misma dirección por muchos años.
He has no history of violence.
No tiene antecedentes de violencia,
I do not know the size or weight of the alleged victim in the case.
Y su abogado no sabe ni el peso ni cuánto mide la supuesta víctima del caso.
I do know that Mr. Gonzalez is 5 foot tall and 145 pounds.
Pero sí sabe de que usted mide 5 pies y pesa 145 libras.
And he is 65 years old.
Y tiene 65 años de edad.
The family has asked that I request this court place Mr. Gonzalez on pretrial release.
Su familia ha solicitado que le pida a la jueza de que lo ponga usted en el programa de libertad anterior al juicio.
I have no doubt that Mr. Gonzalez will abide by all court orders not to have any contact with the alleged victim.
Y él está seguro que usted, señor González, va a obedecer todos los requerimientos de que usted no tenga ningún tipo de contacto con la supuesta víctima.
And will stay as far away from him as this court deems appropriate.
Y se va a mantener alejado de la víctima en la cantidad de distancia que la jueza considere apropiado.
I'm sure Mr. Romero may have some additional information regarding Mr. Gonzalez.
Va a hablar el fiscal sobre información adicional sobre usted, su caso, señor.
The only additional information I have is, Mr. Gonzalez is about 66 years old. The alleged victim is about 25 years of age.
La única información adicional es de que usted, señor González, tiene 56 años y la víctima tiene 25.
66 años.
66, perdone. Y la víctima 25.
Judge, Mr. Gonzalez is about 5 feet tall. The alleged victim is about 5'6".
Que usted mide 5 pies y la víctima mide 5 pies con 6 pulgadas.
The alleged victim probably outweighs Mr. Gonzalez by a good 40 pounds.
Y que pesa como 40 libras más que usted.
Mr. Gonzalez is looking forward to his day in court.
Sorry, interpreter, didn't hear you.
Mr. Gonzalez is looking forward to his day in court.
Usted está esperando comparecer ante el juez, el día en que comparezca ante el juez.
Financially, he's not going to be able to post a monetary bond.
Financieramente no puede usted pagar esa fianza monetaria.
He's going to be relying on his family.
Y está dependiendo de su familia para que hagan eso.
Obviously, my colleague had an opportunity to speak to the family, and I believe what they're going to be asking for is pretrial release, so that's what our position is, Judge.
También su abogado que está junto a usted está pidiendo que le den la libertad bajo palabra, tal cual como el abogado de la defensa de acá ha hablado con su familia. Y están pidiendo de que le permita a la jueza que se tomen fotografías de las lesiones que usted sufrió.
All right, the court will grant the photo order, and I'll let you speak in a moment, Mr. Linder. Court does note that when the officer spoke with the victim, had a laceration to his lower lip, blood on his lip and chin, and blood stains on his shirt.
También sí, la jueza va a aprobar que le tomen las fotografías de las lesiones, pero que también cuando los oficiales hablaron con la víctima tenía una laceración en el labio inferior y manchas de sangre en la camisa.
Also states in the probable cause affidavit
También dicen en el affidavit de caso aprobable
that after the defendant was in his truck for several seconds,
que después de que usted, el acusado, estuvo en su automóvil o camión por varios segundos,
in a separate act of aggression,
se cometió una agresión aparte de las que ya se mencionaron.
the defendant took a 3-4-foot metal club
Que usted tomó un palo de 3 pulgadas
and rushes the vehicle that the alleged victim is sitting in.
y se aproximó al vehículo donde estaba supuestamente, la supuesta víctima estaba sentado.
Okay, state.
Well, and yes, Your Honor, I would rely upon the information that the court just read, that this,
El fiscal está basándose o confiando en la información que le acaba de leer la jueza
that first, this is not a situation of mutual combatants,
y que en primer lugar este incidente no es una situación de combate mutuo
and that age, height, and weight discrepancies, regardless of those, that using a 3 to 4 foot metal club is a great equalizer.
que aparte de que la edad, la altura y el peso no es una cosa que pese en este asunto, todo se va a ver de la misma manera por haber usado ese agresión con ese madera o instrumento de 3x4.
And would also just note that, Your Honor, there's video surveillance evidence and an independent witness's version of events that support the allegations you referred to.
Y también quiere mencionar que hay un video que apoya todas lo que se ha mencionado.
Additionally, Mr. Gonzalez's own admission that he grabbed the metal club and attacked the victim because he wanted to get even.
Y usted mismo, señor González, usted mismo ha admitido agarrar ese palo para golpear a la víctima, para ponerse a la misma altura.
Based on these allegations, Your Honor, I would be requesting a $4,000 bond on count 1.
Entonces, en base a todos esos alegatos, el fiscal está pidiendo $4,000 en el primer cargo.
And ask that the $1,000 bond be kept in place on count 2.
En el segundo cargo, $1,000.
And I believe the court already ordered no victim contact and no return to the Worldwide Auto.
También están pidiendo que usted ya no tenga contacto con la víctima, le prohíben contacto con la víctima y que no regrese a ese lugar de
Worldwide Auto.
Worldwide Auto.
And I apologize if the court hasn't, then we would ask that those conditions also be imposed.
The portion of Mr. Gonzalez's statement that the state admitted
La porción dice su abogado que la porción de esa parte donde dice que usted ha admitido
is that Mr. Gonzalez stated to the officers
es que el señor González le dijo a los oficiales de policía
that the alleged victim was the aggressor
que la supuesta víctima era de hecho el agresor
and had kicked Mr. Gonzalez in the chest.
y que lo pateó a usted en el pecho.
I'm sure the videotape will reveal what happened.
Estoy seguro, dice su abogado, que el video va a revelar lo que de hecho sucedió.
We do not have that videotape here.
Pero no tenemos en este momento el video aquí.
All right, this is what the court's gonna do. Count one, $4,000. Count one, $4,000. Count two, $1,000.
Cargo y en el segundo cargo 1,000.
No victim contact, direct or indirect,
No puede tener usted contacto con la víctima, ya sea directa o indirectamente.
with the alleged victim, Daniel Diaz.
El nombre de la supuesta víctima es Daniel Díaz.
No contact, direct or indirect, sir, means
Señor, que no tenga usted contacto directo o indirecto, quiere decir
no contact in person,
que no puede tener usted contacto con él en persona.
texting, calling,
No puede textearle, no puede llamarlo por teléfono.
no contact in writing,
Tampoco puede escribirle.
no contact through third parties,
Tampoco puede ponerse en contacto con él a través de terceros.
and no contact through social media.
Tampoco puede contactarlo a él por medio de los medios sociales de la Internet.
In addition, sir, you're not to return to
Tampoco puede
Worldwide Auto.
no puede usted regresar al lugar del
Hey, I
incidente.
need the address of that.
Yes, ma'am.
Le van a dar la dirección.
Would it,
The 1100 North State Road 7.
yes, ma'am.
Es 1100 North West
North State Road 7.
Road 7, no, Road 7
Hollywood.
in Hollywood.
Five has been, since last week, and the commercial manager sent him to that place because that people requested
Brian.
him to go.
No, you just let her know we can.
All right, we're in the middle of a hearing. Do we need to?
No, I just straightened something
Talk something else? Okay, all right. If you'd like to say something, ma'am, I'll give you the opportunity. I didn't think you wanted to say anything.
Their question, Judge, was that the owner of the business has actually requested Mr. Gonzalez be the one to bring parts from AutoZone to that location, and I advised them that Mr. Gonzalez cannot go to that location as a condition of his bond.
Señor, su abogado, como condición de la fianza, ya les hizo saber a sus familiares que usted no puede regresar a ese lugar.
Is there anything further you'd like to state, either one of you?
This fight is been for the last week. This guy's been calling my dad, and my
You
dad,
gotta talk a little bit slower so the interpreter can translate.
so that my dad doesn't answer the phone
Okay,
to him.
Su hija le está diciendo a la señora jueza de que la supuesta víctima lo ha estado llamando a usted desde hace
Friday,
unas-
last Friday.
desde el viernes pasado y que usted no contestó el teléfono.
Yeah, I got a call from his co-worker yesterday.
El
And
día de ayer su hija recibió una llamada de una persona que trabaja con usted.
his name is Julio, and he's telling me that.
De nombre Julio, y él le ha dicho eso a su hija.
Yeah, also, he knows that he can go back to that place,
También usted ya sabe de que usted no puede regresar a ese lugar.
but the commercial manager sent him to that place to deliver the piece.
Pero que el manager suyo, el manager comercial suyo, lo mandó a usted a ese lugar para entrega de esas piezas.
Because this person called the manager and request him to go.
Y porque esta supuesta víctima llamó al manager y le solicitó que usted personalmente fuera a entregar esas piezas.
That's all.
Anything you'd like to say, sir?
I just want to say that I used to work in the same company. I know the people from this shop, unfortunately, and I know they are troublemakers. That's all what I could say.
All right, so, Madam Interpreter, you can step up, I'm not finished. No, you can step up to the podium, okay. All right, so let me start from the top, sir.
Señor, voy a empezar por el principio.
$4,000 bond on the aggravated battery with a deadly weapon.
En el cargo de agresión física con agravante con arma mortal son $4,000,
Which was requested by the state.
de acuerdo a lo que ha solicitado el fiscal.
Battery caused bodily harm, count $2,000 bond.
El segundo cargo, que es agresión física con gran daño corporal, es $1,000,
Which was also requested by the state.
que también ha sido solicitado por la fiscalía.
No victim contact, direct or indirect.
No puede tener usted contacto con la víctima, ya sea directa o indirectamente.
With the alleged victim with the initials DD.
La supuesta víctima con iniciales DD.
So you understand what direct or indirect means, sir, what I previously just stated to you?
Tal cual como le indiqué previamente, señor, usted ya sabe lo que quiere decir, que no puede tener contacto ni directo ni indirecto. Ya.
All right, you're also to maintain 1,000 feet
También, señor, se tiene que mantener alejado 1,000 pies
from the Worldwide Auto,
de la tienda Worldwide Auto,
which is at 1100 North State Road 7,
que queda en el 11,000 Northwest
State Road,
State Road 7
Hollywood, Florida.
en Hollywood, Florida.
Or any other place the alleged victim works,
O en cualquier otro lugar donde trabaje la víctima.
you're also not to go to and maintain 1,000 feet
También se tiene que mantener usted alejado 1,000 pies y no puede ir
from the alleged victim's residence
de la residencia donde vive la víctima.
whose specific address is listed in the probable cause affidavit,
La dirección está escrita en el affidavit de causa probable,
which is on Avenue in Hollywood.
La residencia de él queda en Hollywood Avenue en Hollywood.
So there's no return and maintain 1,000 feet.
Usted no puede ir para allá y se tiene que mantener alejado 1,000 pies
From the alleged victim's home.
de la casa donde vive la supuesta víctima.
And no return to Worldwide Auto.
Tampoco puede usted regresar a Worldwide Auto.
Anything else, Dave?
I believe that covers it, Your Honor.
Okay, thank you very much, sir.
Eso es todo. Gracias.
Can we make an announcement fast, just to make sure? I don't think there's anybody else, Mr. Rydell, but we have to make an announcement. Go ahead.
¿Hay alguien más que necesite la intérprete? ¿Que necesite alguien que le traduzca?
All right, anybody at North Broward? Thank you. Anybody at Conti needs Spanish interpreter? Hi. No, ma'am. Thank you. Anybody at Paul Ryan? Okay, thank you so much. We might see you this afternoon.
Thank you.
All right.
Hey, Judge.
Hi.
How are you?
Good. Hold on just one moment. So, this is for Gonzalez right there, okay? All right, Mr. Rydell, we have,
Judge, I appreciate, I don't know if it was Mr. Linder or the court or whoever called for me.
I think it was Brian. I think
Brian, thank you, Brian. Joshua Rydell on behalf of George Davis.
okay, what page is he on?
I don't know. 14.
Thank you. All right, so, Mr. George Davis, you have count one, possession with intent to sell, manufacture, deliver cannabis within 1,000 feet of a school, child care, or park, $5,000 bond. Count two is a municipal ordinance. There's no bond attached to that. I believe Mr. Odom from Mr. McLawrence's office was here, and Mr. Davis indicated that you would be representing him on that as well, which is a possession of an alcoholic beverage charge, Mr. Rydell.
I'll take care of that. That's fine, Judge, yes.
All right, and then count three was a capias for another alcoholic beverage violation. Just to let you know, your client did no show at arraignment on April 9th, 2018, before Judge Robert Diaz.
Okay, well, that's a little strange because I do represent Mr. Davis on most of his matters. I'll obviously look into that. Judge, I'm not going to be arguing PC today, and I would actually stipulate to PC on the predicate offense, and I would just ask the court set the standard bonds in the matter.
All right, so it's 5,000, nothing on two, and count three is a capias misdemeanor, $100. You might want to write this date down. Judge Diaz, and if you bond out, sir, you have to go before Judge Diaz, May 10th.
Yes, ma'am.
At 11 a.m.
Your Honor, I do have to advise the court. Mr. Davis is currently out on $4,000 worth of bond for possession of firearm by convicted felon, possession of cannabis with intent to sell, possession of alprazolam, and battery. He's also been to prison in the past, 2012 and 2013 for sale, delivery of cannabis at or near a park, place of worship, or a convenience store business. He violated probation, was sentenced to 2-year state prison. In 2004, he was sentenced to 3 years prison for possession of cocaine with intent to sell, distribute. He's gone to prison for possession of cocaine in the late 90s and delivery of cocaine in the late 90s for just under 19 months state prison.
Okay. All right, so I'll let the division judge deal with that.
Thank you, Judge.
Hold on. So it's 5,000 on one, nothing on two, $100 on three. Sir, is your address 1391 Northwest 54th Terrace, Lauderhill?
Yes, ma'am.
All right, thank you very much. Good luck to you. Thank you, Mr. Rydell.
Thanks,
Have a
Judge.
good day. Okay, that's for Gonzalez. All right, so we're back to our regular docket. Patrick Shane Young, please.
Patricia, and she is in North Broward, Judge.
Patricia, I'm sorry.
That's all right.
Hello, how are you?
Fine, and you?
Fine, thanks. All right, ma'am, you have loitering or prowling, $25 bond, and then you do have an out-of-county hold for a felony. There's no bond hold. That is out of Dade County for grand theft.
Would like to resolve the loitering and prowling, Judge.
Sure.
Offer to be time served.
Ms. Young, would you be willing to give up your right to trial, enter a
Sir,
plea of
raise
no
your right hand.
contest?
Ma'am, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am, yes, ma'am,
All right, your name is Patricia Young, Y-O-U-N-G.
yes, ma'am.
All right, go ahead, Mr. Reedy.
Are you willing to give up your right to a trial and enter a plea of no contest to this charge in exchange for time served as the state has offered you?
Yes,
Okay.
ma'am.
Okay. Did you speak to her about, that this could affect her sentencing?
It's a loitering and prowling,
Okay.
so
Well, let
I
know
told her
what
not to
other
loiter and
charges-
prowl anymore.
Okay.
No more
It's a
loitering
date.
and prowling, Ms.
What
Young.
about her grand theft case?
It's a Dade County.
Well, that's a
case.
Dade County case,
No, I
Judge.
understand, but this could affect.
Yeah, from what we discussed, I don't believe that it will.
We just lost.
I violated Indeed.
Okay, ma'am, don't talk about the facts of your case. Put your hand down, by the way.
I'm sorry.
That's okay. All right, ma'am, it's my understanding you wish to waive your right to a trial.
Yes, ma'am.
Is anyone forcing you to do this?
No, ma'am.
Are you under the influence of any drugs or alcohol?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Are you on any medications?
Here, yes.
All right, does your medications, don't tell me what they are, do they affect your ability to understand what's going on here today?
Not at all.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and could affect your ability to remain in the United States?
Yes, ma'am.
All right, you've had enough of time to speak to Mr. Reedy?
Yes, sir. I mean, ma'am, I'm sorry.
That's okay. Who is the public defender? That's the gentleman that you spoke to today?
Yes, on the phone?
Yes,
Yes, that's me.
that's him.
Oh, thank
That's
you.
Mr. Reedy. You're welcome. Okay, so you've had enough of time to speak to Mr. Reedy?
Yes.
And you
And now this, all I'm waiting on is Dave to pick me up.
Yes, but let's finish doing the questions, okay?
Oh, I thought you, I'm sorry.
No, that's okay. All right, you understand by entering this plea, it could affect your sentencing somewhat for your case that's pending in Dade County. Could be used against you.
I don't understand what that means.
Right, you want to explain it to her, Mr. I don't know.
Sure. Patricia, this is going to be on your record as a loitering charge. I don't know if that would have any effect on the grand theft in Dade County. You had indicated to me that you had already violated in Dade County, so I doubt that this will have anything to do with it. But you do need to go down to Dade County and resolve that matter.
Okay.
Okay?
All right, so understanding what I explained to you and Mr. Reedy just spoke to you about, you want to plead guilty, not guilty, or no contest to loitering or prowling?
No contest.
The court is going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate your time, serve you $293 in court costs. Thank you, ma'am. Good luck to you. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck to you. You should be going down to Dade pretty soon. You're done with this case, except for paying the $293 in court costs, okay?
Okay.
Thank you.
And it should be like soon?
Hopefully it will be, ma'am, yes. Okay?
Okay.
Thank you.
Thank you.
Okay, Chondis Kendrick.
All right.
Hello, how are you?
Hello.
All right, you have one count of possession of cocaine, $1,000 bond. Count two is introduce contraband into a detention facility, $1,000 bond. You do have two violations of probation. You are being released on your own recognizance on both of those. Your division judge is Judge William Howery. You do have a court date if you bond out, and if you don't, you're gonna have a warrant for your arrest, and it's probably gonna have a bond attached to it, which is this coming Tuesday at 8:30 a.m. for your violation of probation before Judge Howery. Do you understand?
I'm sorry, could you repeat that?
All right. You have two violations of probation, counts 3 and 4. Your division judge is Judge Howery. Judge Howery has set a hearing on May 8th at 8:30 a.m.
Okay.
Do you understand that?
Yes.
So if you bond out of jail, that you have to show up in court on those violations of probation at 8:30 a.m. at the courthouse here before Judge Howery. If you don't, a warrant will be issued for your arrest, and I'm guessing, and it's probably a very good guess, that you're not going to be ROR'd on the violation of probations. They're going to revoke that, okay? So you got to show up this Tuesday at 8:30 a.m. before Judge Howery. On the other two cases, the possession of cocaine and the introduction of contraband, court does find probable cause. Does anybody wish to be heard with regard to the $1,000 bond on each one, Mr. Reedy?
Judge, I'd ask you to release Ms. Kendrick on her own recognizance on these charges. It doesn't say how much cocaine is involved, but it was in her right front pocket, they say. It doesn't indicate either that she was asked if she had anything on her possession. It doesn't say what answer she gave. It says upon entering the jail, the clear plastic bag was found in her right front pocket. Judge, she has got to be in court on May 8th. If she's not, there's going to be a no bond hold issued for her from Judge Howery. She's already under the supervision of the Department of Corrections on that probation case for 2 felonies. So I think that's sufficient incentive for Ms. Kendrick to appear in court on May 8th. So I'd ask you to consider releasing her on her own recognizance on these 2 charges.
But she also has one of the allegations for the violation of probation.
That's right, Judge. But Judge Howery found that it was okay to release her on her own recognizance, which is something, quite frankly, we don't see very often. Usually when there's a violation of probation warrant, it's a no bond hold.
But now we're up to a possession of cocaine, another charge.
Yes, I agree with that, but she is still on probation, so she is under the control of the Department of Corrections as we speak.
All right, State, what say you?
Your Honor, and basically what I think the bond should be kept in place. Frankly, what the court could do, and I don't know if anyone could advise me, but if there's a 94806 arrest, under the new administrative order, a person needs to be brought before their judge the next day, correct? No, I know. I'm getting there, though. But my understanding, under the new administrative order, if there is a 94806, defendant has to be brought before their judge the very next day, correct? I believe that's what the administrative order says. Your Honor, you have a basis to find a violation of probation under Florida Statute 94806 and allow her to see Judge Howery tomorrow, and then he can make a determination how to proceed. But as you stated, when he ROR'd her on the warrant, obviously there was no allegation that there was a new law offense being committed. And that is a very different level of violation between a technical violation and a new law offense.
One's dirty urine.
It's a dirty urine and cost. They're both technicals.
All right, let me ask you this. What can she afford in bond?
Ms. Kendrick, what type of bond can you afford?
I can pay the $200.
$300?
She said she could pay the 200.
How much? 200?
I have, yes, I have 2 $1,000 bonds.
Oh, yes, you do. Can you make those bonds?
Yes.
Okay. Then I'd ask you to leave them where they are then, Judge.
Bond in place. All right, if something changes, don't forget, this Tuesday, May 8th, 8:30, Judge Howery, okay?
Okay, thank you.
Thank you. Who's the other person sitting there in Paul Ryan?
I believe that is Miss Pierre Louise.
Oh, next one, okay, come on up. Good morning, ma'am. You have a grand theft between $300,000 and $5,000.
Does she have anything?
Court does
Pierre
find
Louise.
probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim in this case, with the initials AGL. Do you understand?
Yes, I understand.
All right, is your address 4050 Northeast First Ave, Oakland Park?
Yes, it is.
All right. Defense?
Judge, it appears to be a crime of opportunity. I believe Miss Pierre Louise has lived at that address for a lengthy period of time.
Okay.
I'd ask the court to consider releasing her on her own recognizance. As I say, it appears to be a crime of opportunity, maybe a moment of bad judgment. I don't know what her prior criminal history is, but if it's not extensive, I'd ask the court to consider releasing her.
I'd have no objection to pretrial. I mean, I think every theft is a crime of opportunity. What's concerning is that even when the victim spoke to her and she had the phone right there and had an opportunity to say, hey, here's the phone you're looking for, she still didn't.
We would not object to pretrial release, Judge.
Okay, no victim contact, direct or indirect, with this alleged victim. No return, ma'am, to the Walmart where this incident occurred. Do you understand? Yes, ma'am. If you do return to the Walmart, you will be arrested. Okay? ROR, thank you very much, ma'am. Good luck to you, okay? Look for your court date in the mail. ROR. Okay, thank you very much. All right, next one is Mary Lynn Shanera.
I think she's still a medical reset, Judge.
No, she's not a medical reset, Your Honor, but she is in courtroom 4870.
Oh. Okay, good.
All right, here you go, Willie. Standard pretrial, and I RO order, yes. Yes. All right, Geraldine Ann Ficht, F-I-C-H-T. All right, she was a medical reset yesterday. Madam Clerk, just to let you know, so you don't have to do another page, Ms. Jackson. Okay? All right, David Brown. Sometimes some clerks do right on the top of it.
Yeah.
I don't know why.
But not me, because Tanya did.
I know.
Yeah.
David Brown, please. Is there a David Brown? Does anybody know where David Brown is? Is he at North Broward?
Judge,
All right, Paul Ryan.
it's a municipal ordinance case.
He bonded. Thank you very much. David Brown bonded. Yes?
How you doing?
All right, I got. All right, Eugene Freville?
Yes, ma'am.
All right. Sir, you have a capious misdemeanor and ad charge carrying a concealed weapon. You no-showed at calendar call. You have a $5,000 bond. You are going before your division judge, Judge Melinda Brown, on May 10th at 10 a.m. Good luck to you, sir.
All right, thank you.
Thank you. Anthony Gutierrez, please. Did anybody hear back from Mr. Solomon?
No, Your Honor.
Mr. Gutierrez is here at Main Judge. You can find the service.
Okay, Mr. Gutierrez, good morning, sir. Count 1 is DUI, alcohol, or drugs. First offense, $500 bond. Counts 2, 3, and 4 are DUI with damage to property or person of another. They each have a $1,000 bond, so that's $3,500 total. And count 5 is driving while license is suspended without knowledge. There's no bond attached to that. And then counts 6, 7, and 8 are basically civil traffic infractions, possession of an open container in a motor vehicle, operating a vehicle in unsafe and improper equipment, and careless driving, which the 3 of them, no bond attached. So the total is $3,500 in bond. The court does find probable cause. Can you pay the $3,500, sir? Is there someone else that can pay the $3,500?
I believe so, yes.
All right, who is that, sir?
My father.
All right, has anybody been able to contact your father?
No, not yet.
All right, so have you asked to try to call your father?
He said whether or not he was supposed to have that come here.
All right, is there a deputy at North Broward that we can get somebody to allow Mr. Anthony Gutierrez the opportunity to call his father to see if he can post bond?
He's not over here, ma'am. He's not in North Broward.
No, I'm talking to the people, I'm sorry, at the main jail. Okay, sir, what is your name at the main jail? Okay, I'm talking, okay. So is there a deputy at the main jail that can allow Mr. Gutierrez, I'll recall the case, the opportunity to call his father to see if he can post the bond. Yes.
Yes, he'll be able to use the phone when he returns to his unit.
All right, what about now?
There's no phone in the courtroom that they can use, but as soon as he returns to his unit, he'll be afforded the opportunity to use the telephone.
All right, Mr. Gutierrez, we'll recall your case this afternoon, okay? 1 o'clock.
Okay,
Thank you.
thank you.
Deputy, please make sure someone allows him to make a call to his dad. Corey Parkinson, please.
Mr. Parkinson is here at Main Church.
Okay, Mr. Parkinson, you have trespass to structure or conveyance, $250 bonds. Anybody wish to be heard?
Judge, he wishes to ask for
State.
One moment, Your Honor. Your Honor, the plea offer that has been documented by the assigned Assistant State Attorney would be a withholding court cost, no return to 1614
Hold on, 1614.
Northwest 45th Court,
I'm sorry,
Northwest 45th Court,
45th Court, where's
And-
that?
Tamarack.
Okay, is that what your client wants to do?
He wishes to accept the state.
All right, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
Are you Corey Parkinson, Parkerson?
Yes, ma'am.
All right, you can put your hand down, sir. Sir, it's my understanding you wish to waive your right to a trial and plead guilty or no contest to trespassing?
No contest.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
All right, you agree not to return to 1614 Northwest 45th Court, Tamarack, Florida?
Yes, ma'am.
You understand that if you return there, you're gonna be arrested?
Yes, ma'am.
All right, so no contest to trespass. The court's gonna accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea, withholds adjudication plus $293 in court costs. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. The court does take judicial notice of the time that you served in the Broward County Jail. Thank you, sir. Good luck to you.
Good luck, sir. Yes, sir.
David,
Mr. Melnick is
yeah,
here.
no, just that's for you. I want to reset it to the PM. The deputy at the main jail told me that he can't make a phone call from here. He has to be returned to his unit. So let him return to his unit, let him come back at 1 o'clock where he can make the phone call and we can find out if he can post the bond. So in other words, I just want to recall it, reset it for one today. David Joseph Milnick, is that right?
Melnick, ma'am.
All right, sir, you have trespassing on unoccupied structure or conveyance, $25 bond. Court does find probable cause. Sir, you're not to return unless you have a valid reason for being at Memorial Regional Hospital. Do you understand?
Yes, ma'am.
That means you have to have an appointment there, be either visiting someone and they have to be in the hospital, or you're there for a medical purpose for yourself. Do you understand?
Yes, ma'am.
Okay, so what are we doing with this $25 bond?
State's offer would be time served.
He wishes to accept the state's offer, Judge.
All right, sir, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Is your name David Joseph Milnick, Mlynick?
Yes, ma'am.
All right, I'm glad I said, okay. All right, sir, it's my understanding you wish to waive your right to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Not on any medications at this time that would affect your ability to understand what's going on here today?
No, ma'am.
Okay, you understand that if you're not a U.S. citizen, a plea to discharge could result in deportation proceedings?
Yes, ma'am.
All right, understanding what I just explained to you, do you want to plead guilty, not guilty, or no contest to trespassing, unoccupied structure, or conveyance?
West Side Lake, Michelle.
The court's going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea, adjudication time served, 293 in court costs, no return to Memorial Regional unless it's for a valid purpose. Thank you very much. You have 30 days to appeal the sentence to the court. Can't afford an attorney, one will be appointed if I didn't tell you already. Next one, good luck to you, sir. Bo Jason Patello.
He's in North Broward, Judge. It's a municipal ordinance case that I believe he would like to resolve.
Okay. Hello, Mr. Patello, how are you?
I'm all right, ma'am. How you doing?
Good. All right, sir, you have two different charges, unlawful assembly and open container of alcohol. Do you want to resolve your case today, or you want to bond out of jail? You want to fight your charges? What do you want to do?
I want to resolve it.
All right, do you have a place to live?
I'm staying between houses with friends.
All right, you know, there's a place, sir, that's called the Centralized Receiving Center at Henderson. That's a really nice program that they started, and you basically go there, you can take a shower, you can stay there for a while, you can get a meal, they clean your clothes, and they try to help you find housing and help you with other things. You can voluntarily leave at any time. Is that something you'd be interested in?
If I could get the address to it and stuff, I would technically.
Well, we could have you transported there from the main jail. They'll pick you up. You could leave at any time.
No, I'd rather go back. I drive my stuff back to Boca and stuff.
All right, sir. You're not gonna be back here again on these charges, are you?
No, sir, no, ma'am. I was in court. I was in jail when I missed court for these charges. I was already incarcerated. I had these charges. I was supposed to be in court December, and I was in jail from November to February.
Okay, you want to resolve these cases today, right?
Yes, ma'am.
Okay, adjudication time served, and I have to impose court costs. Is that something you'd like to do?
Yes, ma'am.
All right, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, your name is Bo Jason Patello, B-O-T-E-L-H-O?
Correct.
Okay, it's my understanding you wish to waive your right to an attorney and trial, sir.
Yes, ma'am.
Is anyone forcing you to do this?
No, ma'am.
Not under the influence of any drugs, alcohol, or medication, are you?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Okay, how do you want to plead to open container alcohol and unlawful assembly? Guilty, not guilty, or no contest?
No contest.
The court is going to accept your plea, sir, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court is going to adjudicate you and time serve you on each count. And the court has to impose $78 on each count in court costs. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you.
You too, ma'am. Thank you. Have a blessed day.
You too. Timothy Lee Hall, please. Yes.
Sure, hold this problem with this young man. Can you take one guy, Your Honor? He's having a tough time.
Sure. Who is it?
Trying to get him to hang in. Brittany,
What page?
page 10.
Okay, let's call him. Should have told me. Next time, let me know, deputy.
Thank you very much.
You're welcome. Next time, let me know, deputy.
Britain, page 10.
Hello.
Hi, Mr. Britton. How are you?
I'm fine.
All right, Mr. Britton, you have a charge of battery.
Yeah,
It's a capias, actually.
yeah.
Says no bond issued for failure to appear.
Yeah.
That is Division MI, which is Judge Lerner Wren. So you're going to be held no bond, sir. You are going before your division judge May 10th, which is a week from today, at 2 p.m. Maybe someone from your office, Mr. Reedy?
Yes, I spoke with Mr. Britton earlier today, Judge. I'll do what I can to see if I can move that up. I honestly don't know if I'll be able to or not, but we'll see.
Okay.
Okay, Mr. Britton, you all right?
Oh, yeah, I'm
Okay, man, you take care, all right?
All right, feel better, sir, okay. Thank you, Deputy.
Thank you.
All right, Timothy Lee Hall, please. All right, Mr. Hall, you're here operating without a valid license, $1,000 bond, and you also have failure to pay child support, $700. That was issued that's from 2013, actually. Judge Keith and Frank, it's actually 2017. Would you like to resolve the operating without a valid DL, Mr. Romero?
He would.
All right, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
All right, state, what's the plea offer?
Plea offer is adjudication time served.
Okay, sir, would you like to take an adjudication and time served for the operating without a valid license?
Yes, ma'am.
All right, you understand you're not going to get out of jail today because you do have the $700 child support issue unless you can pay that. You should be going before your division judge, Judge Keith and Frank, within the next 48 hours, okay, on the child support charge. So your name is Timothy Lee Hall, H-A-L-L?
Yes, ma'am.
Okay, my understanding, you wish to plead guilty or no contest to operating without a valid license?
Yes, ma'am.
Which one is it, sir? Guilty or not guilty or no contest? All right, no one's forcing you to do this, right? Not under the influence of anything? You understand what's going on here today?
Yes, ma'am.
All right, court's going to accept your plea, find that it's freely and voluntarily given. Court has reviewed the court file and finds probable cause for the plea. Adjudication, time served, $293 in court costs. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, sir, except for paying the $293. Indell Sandville, please. Okay, Mr. Sandville, good morning, sir. You have a trespass property, not a structure or conveyance. Bond is set at $25.
Mr. Samuel is requesting the court to resolve this case today.
Okay, Mr. Sainville, do you have a residence, sir? Do you live somewhere, or are you homeless?
I live in a project.
What's your address?
1603 Northwest River Circle, up in 986.
All right, you know what? I'm not gonna resolve his case today. I'll ROR him, okay? He's gotta show up for court. Your notice, sir, is gonna go to 1602 Northwest 11th Ave, Pompano Beach, Florida. Look for your court date or go to a public library if you don't have internet. Go to browardclerk.org. You'll be able to look up your date, or you can call the clerk's office, or you can come to the courthouse. There'll be a date coming in the next 7 to 10 days, so check on it if you don't get notice, okay? If you don't show up, sir, there's gonna be a warrant issue for your arrest. Next one is Javane McDonald, please. Okay, Mr. McDonald, you have possession of cannabis, 20 grams or less, $100 bond. Count 2 is possession of drug paraphernalia, no bond attached. Court does find probable cause. What are we doing with this case?
Judge, he's going to be posting his bond, or the alternative, Your Honor, this is a cannabis offense. I don't know if you would straight out warrants for bond.
State, any objection? Is your address
He's
7900 Northwest 3rd Street, apartment 202, Hollywood?
Yes, ma'am.
Okay.
I would oppose. He's out on bond, possession of cannabis with intent to sell.
Did he bond out on that?
Let's see.
Can you afford the $100, Mr. Romero?
Yes, Judge.
All right, $100 bond, thank you.
He's on $1,000 bond.
Aaron Gerber Rodriguez, please.
Mr. Rodriguez, come on up, please.
Good morning, Mr. Rodriguez. You have driving while license is suspended. First offense, $100 bond. You do have count 2, which is an expired driver's license over 6 months. There's no bond attached to that, so it's essentially an ROR. Count 3 is operating a vehicle with unsafe equipment, possession of an open container. Those are both basically an ROR. However, you do have an out-of-county hold for a misdemeanor where you have a no bond hold. Court does find probable cause. Anybody want to be heard with regard to count 1?
Judge, I do understand count 5, I believe it's an out-of-county hold from Palm Beach, is a DOT. Would Your Honor consider an ROR on count 1 to Palm Beach and come and pick him up?
Any objection, State?
Nope.
Okay, no objection by the State. Sir, is your mailing address 478 Lock Road, apartment 196, Deerfield Beach?
No, Your Honor, it's actually 660 Siesta Key Circle, 2524, Deerfield Beach, Florida.
Okay, hold on, because I was writing it down. Okay, so it's 660 Siesta Key Circle, apartment,
2524.
okay?
That is in Deerfield Beach, Florida, 73401.
Okay, so on count 1, the court will ROR. And the rest I don't need to discuss bond. If you have any other cases pending in Broward County, sir, or anywhere else, you might want to advise them of your new address, okay? I've done it in this one. Thank you. Good luck to you. Next one is Zahedi Jerome Watkins. Okay. All right. Yeah, back them up a little so I can see them. Okay. All right, are you Zebedee Watkins, sir?
Yes, ma'am.
All right, sir, you have a charge of trespassing, occupied structure or conveyance, $100 bond, and then you have a petty theft. Second degree, it's your second offense. Okay, depending on what happens with this case, if this happens again, sir, and you're convicted of the first 2, they can, charge you as a felony, even though it's a petty theft. So bond's been set at $100. Anybody wish to be heard?
I'm gonna ask that he go to Judge Lerner Wren. I can tell you his last.
No objection.
Yeah, all right.
Okay, sir, we're gonna send you to Judge Wren. You're gonna call up, right, Mr.?
Yeah, I will text her, Jay.
Okay. We're gonna leave the $100 bond in place. I have a note on here that it's case number 183965,
Yes, it is.
MM10A. I don't know if that's stated somewhere else.
I have
Find
it.
probable cause. All right, thank you. Marvin Geralt Lopez, please.
Conti again.
All right.
Lopez.
Okay, Mr. Lopez. Hello, how are you, sir? Fine, thank you. You have a capias, it's a not in custody, for a grand theft, it's an ad charge, count 4. Bond is set at $1,000, court finds probable cause.
I'd ask you to leave the bond in place, Judge. Mr. Geralt Lopez has no bond holds on count 1 and 3, and he has a court date May 7th.
Yep, that's what I have. Division FI, which is Judge Barbara McCarthy, May 7th at 8:30. That's this coming Monday, sir. Bond is set at $999. Thank you, sir. Good luck to you, okay? Next one is Thomas Michael Rowe, please.
Conte.
All right, Mr. Rowe, good morning. You have an ad charge, count 6, possession of drug paraphernalia. It's a capias felony. Bond set at $100.
Ma'am, may I ask you what it is, paraphernalia, what in regards to?
State will have to answer that question, sir. But I will tell you, while they're looking, you do have a court date coming up tomorrow before Judge McCarthy at 8:30 a.m.
Yes, I got a reset for the 14th. Thank you. private.
This is just an add charge to his trafficking case. It's really probably the least significant part of the case.
Any objection if I set a $1 bond?
I think Mr. Rowe has indicated that he has private counsel.
Okay. Who is your private attorney, sir?
I had the third, the 34 day for tomorrow. The third is reset for the 14th for status hearing.
Okay, does anybody have Attorney Richard Bellis?
Well, let me ask you this, Mr. Rowe. Would you object to the court lowering your bond from $100 to $1 on this paraphernalia charge?
No, I would not.
Okay.
Okay, $1, sir.
Thank you.
Okay? Robert Mojica? Paul Ryan? Robert Mojica.
Let me double check. That's what the docket says.
Yeah, he's in Paul Ryan. No. Let me check
Okay,
something.
Willie? Call up this number, Paul Ryan, and tell him we need Mr. Mojica here, unless he bonded. Did he bond
He's
for it?
no, he's being arraigned this morning in front of Judge Fine.
Yeah, he has a
Oh,
court.
he is?
Yeah,
Yes,
So what courtroom is that?
I don't know.
he has a court date for 45.
All right, Willie, we'll reset this for this afternoon. Tell him he's before Judge Fine. Can they bring him to magistrate court, okay? All right, next one is Joseph Kane, please.
DeConte?
Okay, Mr. Kane, how are you, sir? Fine, thanks. You have ad charges, counts 4 and 5. Possession of fentanyl, possession of cocaine, $1,000 bond each for a total of $2,000. You are going before your division judge, that's Judge Dennis Bailey, on May 7th, which is this Monday, at 8:30 a.m. Anybody wish to be heard with regard, Mr. Reedy, to the $1,000 bond on each count?
No, Your Honor.
Okay. Does he have a no bond hold or anything?
No.
No, Judge, he's got a $1,000 bond on count 3.
Okay, are you able to afford bond, sir?
No, ma'am.
Your Honor, his bondsman surrendered his bond because apparently he failed to appear in court on counts 1 and 2.
All right, so we'll leave your bonds at $1,000, sir, per the state and the defense. Thank you. You go before your division judge soon. Daniel Alfredo Santana, please.
Medical reset.
Matthew Garland, please.
Judge Matthew Garland was remanded yesterday in division by
He was
Judge.
what yesterday?
He was remanded yesterday in division by Judge
McCarthy.
McCarthy,
Okay.
and the bond was set at $1,000.
All right, so do we have a Matthew Garland?
He's here at Maine, Judge.
All right, Mr. Garland, your bond was left at $1,000. You were in front of your division judge yesterday on this chart, so the court's gonna find probable cause. And she left his bond at $1,000?
Yes.
All right, so court will leave your bond at $1,000, sir. Thank you. Yes,
Speaking of Mr. Garland, I know he's here before you magistrate. I don't know if that's error or not.
It is. That's why it's supposed to be left.
That this case was, he was originally arrested back on February 3rd. State didn't file charges on he was released to ROR on March 8th. From what he's saying, I guess it was dropped and then it was picked back up and now we're here.
it's a represent.
It's a represent, and his assigned judge set a bond, and it was apparently placed here in error.
All right, anything further, Mr. Romero?
Judge, I actually consider an ROR. He was ROR.
No, $1,000 bond, thank you. Justin Rennie Roman? Yes, Willie.
I spoke to the deputy over there. No point. She told me they are all being sent back to their facility.
Why?
I don't know, Judge. She told me they all being.
Who did we, all right, hold on just one moment. Renee Roman. Okay, Mr. Roman, you have count 1, possession of cannabis, 20 grams or less. There's no bond attached. Count 2 is tamper with or fabricate physical evidence. It's $1,000 bond, sir. You do have a warrant for a VOP pretrial felony, which is not for magistrate. You have a no bond hold. Court does find probable cause. Anybody want to be heard with regard to the $1,000?
Considering, Judge, he has no bond hold on the violation of pre-trial release, nothing to add from the defense, Judge. If Your Honor, found probable cause.
Yes, I did. Okay, so court's going to set bond at $999 on count 2. Ladarius Tyvone Adams, please. Okay, Mr. Adams, you have aggravated assault with a deadly weapon without intent to kill. We need to talk about bond. That's on counts 1 and 2, sir. And count 3 is touch or strike battery. Court does find probable cause unless I hear an objection. Wait, it's a habeas, not in custody.
And I'm reviewing I have reviewed the probable cause affidavit online, and I have no probable cause argument.
And,
All right, State, do we have the name
yeah,
and notice?
I was just going to give that to you, Judge. The initials are, it's 2 different alleged victims, AA and RG.
All right, sir, you are to have no victim contact, direct or indirect, with the person with the initials AA and RG.
Yes, sorry.
Okay. Okay, with AA and RG. Did you hear me before what direct or indirect means, sir?
Yes, ma'am, I heard you.
All right. All right, State, any other special conditions?
Yes, Your Honor. Additionally, that he not be in possession of any firearms, weapons, or ammunition.
That's fine, Judge. I don't think Mr. Adams would have an objection to that. I would point out that even though there is probable cause, no firearm was recovered. The independent witness did not see a firearm, and Mr. Adams, when he waived his Miranda warnings and gave a statement to the police, indicated that he never threatened either of these alleged victims with a firearm. So the only evidence against Mr. Adams is the unsubstantiated word of the 2 individuals who were in this confrontation with him. I'd ask the court to take that into consideration when determining an appropriate bond for Mr. Adams.
All right, State.
Well, first, the gun wasn't found. They spoke to him a month after. That they couldn't find a gun a month later, I don't think really is mitigating. And the victim did note that Mr. Adams was the aggressor.
So what are you requesting for bond?
Your Honor, I'm going to be requesting $10,000 on each count 1 and 2, based on the allegations, but also Mr. Adams' criminal history. 2015 grand theft, 2013 burglary of a conveyance and grand theft, VOP, 27.5 months state prison. 2013 another burglary, conveyance, grand theft, VOP, same sentence. Unlawful use of false name ID, 2013. 2011, he was convicted of a burglary structure, 4 burglaries of conveyance, and 3 grand thefts, VOP. Unlawful use of false name ID, 2008. Resisting without violence, 07.
Okay, defense.
Judge, speaking of Mr. Adams, he's 29 years old, been living in our community his whole entire life. At this time, he is employed. He works for a company called Skyland Management Company. He's basically in maintenance. He's been working with that company now for about a year and a half. He gets paid about $100 a day. He is a single father. He lives in Lauderhill. He's been renting an apartment now for about a year and a half. He has 2 children. He supports his 2 kids, and his monthly rent is about $1,100 per month. Right now, his 2 children are with their mother. Right now, that's the person that Mr. Adams is the only person that he's going to be able to contact to help post his monetary bond. She works at Walmart, and unfortunately, her financial resources are very, very limited. Judge, Mr. Adams, he is looking forward to his day in court. He is looking forward to basically defend these allegations. He actually spoke with the arresting officer. saying. He is innocent of these allegations. Judge, my understanding is that this alleged offense happened about over a month ago. There's been no escalation of this incident. There's been no other confrontations with the alleged victim, Judge. He will basically abide by the court's order as far as not having any sort of contact. Judge, financially, though, he just can't afford to impose a monetary bond. He's going to be asking the court to impose a minimum bond with pre-trial release, Judge.
All right, count one, $7,500, count two, $1,500, count three, $100, no victim contact. Sir, you're not to possess any firearms, ammunition, or weapons. Thank you. Okay. Mojica is going to reset for the PM. John Gilmore.
North Broward.
Okay. North Broward, John Gilmore, please.
Yes, sir. He's coming.
All right, Mr. Gilmore. It's coming up. Is that your little shelf there? Yes. All right. Good morning, Mr. Gilmore. How are you?
I'm okay, sir.
I know.
Oh,
All right. All right, sir, you have a capious misdemeanor, count 1 and 2, trespass private property, $100 bond. Count 2 is open container. You have a $100 bond, so it's $200 total. You do have 2 out-of-county holds for felony. Bonds are set at $9,999, which actually are not for magistrate. That's out of Miami-Dade County. Anybody wish to be heard on the open container or the trespass case?
I can't represent Mr. Gilmore on those charges, Judge.
Oh, that's right.
I
right,
think he
sir,
might be inclined to resolve them, though.
I don't know what the out-of-county is, though.
I don't either. One is possession of drug paraphernalia, and one appears to be threatening a law enforcement
All
officer.
right, sir, I don't know what's going on in Dade, so this is what the court's going to do. The court is going to ROR you on the trespass private property and the open container. Let me see what county. This is Hollywood. Is there an address, sir, or a telephone number where I'm going to appoint Stephen Shate to represent him? How can Mr. Shate get a hold of you, sir?
I'm not from down. I'm from Cleveland, Ohio. I have no family here.
Okay, but is there a phone number or someone that you speak to every once in a while?
No, not really.
Do you have a phone?
I have one, but all my stuff is stolen.
What's your phone number?
I don't have a phone.
Are you gonna, when you get out, are you gonna get a phone?
I have to go through all the process, give you another ID and everything, so all the stuff is stolen.
Do you ever get your stuff at 2020 Scott Street, Hollywood, Florida?
Yes, I get my mail there, yes.
All right.
I was told to call the officers that arrested me, they know a little bit about me, so they told me they was gonna try to get out and try to put me in the Henderson program. I don't know nothing about that, but his name is Officer Tom. He knows a little bit about me.
Okay, can we appoint Stephen Shate? Deputy at North Broward, can I give you Mr. Shate's number and you can write it down?
Yes.
Okay, it's Stephen Shate, S-C-H-A-E-T. His office number is 954-728-3776. 3477. Sir, it's gonna be your responsibility to call up Mr. Shate and tell him he's your attorney on two cases, the two municipal ordinances, okay?
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
All right. Do we have an order or something, or you're gonna send it to Mr. Shade? Okay, perfect, thank you. Do you have my stamp there? You do? What does that stamp say? This doesn't have the right date, but there you go. All right, next one is Leroy Williams, please. Leroy Williams.
Here, me.
Okay, Mr. Williams, you have petty theft, second degree. No bond attached. You do have possession of a weapon with a short-barreled gun, rifle, or machine gun. I didn't see, I just saw
Your Honor,
ammo
if I
on
can be
it.
heard, well, Your Honor, I believe what the appropriate charge is and I believe it's the officer's intent based on the language he uses in the probable cause affidavit, is possession of ammunition by a convicted felon. And I note that specifically because the officer or deputy mentions in the very last sentence of the PC that a routine check of Williams revealed he is a convicted felon. And I confirm that also, that he is a convicted
All right,
felon.
so the court does find probable cause only for possession of ammo by a Florida convicted felon?
Yes, ma'am.
Any objection to that, Mr. Reedy?
No, Your Honor, that would appear to be in keeping with the language of the affidavit.
All right, let's talk about bond on count two.
Yes, Your Honor, I'm going to be requesting a $2,500 bond on count two.
Okay.
Mr. Williams is out on bond right now for burglary of a conveyance that is pending before Judge Lynch. He also has 2016 theft, 2015 conviction for possession of PVP, 2012 conviction for delivery of cocaine, 2-year state prison, 2012 conviction for shooting at or throwing a deadly missile, 2-year state prison as a habitual offender. He also has a prior conviction for strong arm robbery, 20-month state prison. He's gone to prison for possession of cocaine as well in the past.
Okay, so he was stealing something allegedly, and when they detained him, a bullet fell out of his pocket.
Yes, and I guess a witness saw bullets prior to that.
He was not in possession of a firearm.
I understand. Okay, Mr. Romero.
Judge, I'm speaking to Mr. Williams. Unfortunately, right now, he's not working. He's currently looking for work. He lives in Pompano Beach with his aunt. She's not in a financial position plus his aunt. He's going to be contacting his nephew. He believes his nephew will be able to help with the bond. He works in landscaping. We'd be asking you to consider setting a $1,000 bond on count two on his behalf, Judge.
All right, no return and no contact, sir, with any Bennett Auto Supply employees. So you can't return there. If you do, you're gonna get arrested. The court is gonna do GPS, open schedule, $1,000 bond. Thank you, sir. Good luck to you. Next one is Millard Seabrooks, please, and then after that is Jesse Alfred. Come on up. Okay, and after that, Mr. Alfred.
Be careful, sir. Come on.
Hello.
Hello, how you doing?
Good. All right, sir, you have burglary, occupied dwelling, unarmed. Court does find probable cause. Court's gonna order no victim contact, direct or indirect, with the alleged victim with the initials ERT. Do you understand, sir?
Yes.
All right. No contact, direct or indirect, means no contact in person, calling, texting, writing, anything on social media. You understand?
Yes, ma'am.
All right, you're also not to return to the residence where this alleged incident occurred, which is located at 419 Northeast 2nd Street in Fort Lauderdale. Is that correct, State?
Yes, ma'am.
All right, anybody wish to be heard?
Yes, Judge. I'm going to be requesting a $15,000 bond, pretrial release with a GPS. I'm concerned not only by the allegations, which also include while Mr. C, he broke into one home that was occupied, and then trying to avoid arrest, broke into another home that was occupied. This all occurring while he is out on bond before Judge Porth for burglary of his structure and criminal mischief. He's also had cases dismissed going from 2005 to 2009, one case for burglary of a dwelling, grand theft, and possession of burglary tools, another case for possession of cocaine, and another case for burglary of a structure and grand theft. In 1998, he was convicted of burglary of a structure and possession of cocaine, sentenced to 5-year state prison as a habitual offender. In 1990, he was convicted of attempted robbery with a firearm or deadly weapon, violated probation, was sentenced to 15-year state prison. In 86, under the name Ray Grant, he was convicted of burglary of a dwelling with assault, violated probation, sentenced to 5-year state prison. He's had 3 other priors for burglaries, either of a structure or a dwelling, and went to prison on those cases.
All right, defense?
Judge, Mr. Seahorse, he's almost 70 years old. He's on disability. He gets approximately $735 per month. From what he informed me at this time, he is homeless. He has family that he could use their address to get correspondence from the court. Unfortunately, from what he advised me, no one's going to be able to help post his monetary bond. Judge, Mr. Seahorse is at this point financially indigent, so I ask you to take that into consideration to determine reasonable release conditions on Mr. Seahorse's behalf.
Okay. All right, this is what the court's gonna do. The court is gonna do a $10,000 bond, no victim contact, direct or indirect, with the alleged victim with the initials ERT, no return to 419 Northeast 2nd Ave, Fort Lauderdale, Florida, and he's to maintain 1,000 feet at all time from that residence. Where is the second place, State? From the 920 Southwest 2nd Street.
Yes.
And 920 Southwest 2nd Street in Fort Lauderdale, Florida. GPS level 2, maintain 1,000 feet from both those residences. Thank you very much. Good luck to you. Do we have the initials? Hold on one moment. Do we have the initials of a second person?
No, Judge.
Okay. Huh? You want them here? Okay, thank you. Jesse Sharp Alfred, please. Okay, Mr. Alfred, good luck to you, sir. You have driving with a suspended driver's license as a habitual traffic offender, $100 bond. Count 2 is a civil traffic infraction, something about your sunscreen or side wind. And count 3, though, sir, is a probation violation or community control. Actually, it says it's a probation violation here. You're going before your division judge, Michael Usan, on Monday, May 7th at 9 a.m. You're going to be held no bond. Court does find probable cause. Anybody wish to be heard on count 1 with the bond?
Hearing has no bond.
All right, $1 bond on count 1. You'll see Judge Usan on Monday, the 7th. Thank you, sir. Good luck to you. Anthony Nigel Seeley, please.
Mr. Seeley, come on up, please.
Hey, hello, Mr. Seeley. Good afternoon. You have possession of forged driver's license or ID, $1,000 bond. Count 2 is fraud or attempt to use ID of another without consent. Any objection to probable cause?
No, Your Honor.
Okay, you have a total of $2,000 bond. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials KSC. I'd like to note that the PC has the wrong name of the victim in the victim section and put the defendant name, but contained within the probable cause affidavit is the alleged victim's initials, KSC. Anybody wish to be heard? Did you hear that, Mr. Reedy? Linder? Go ahead, I'm sorry, I interrupted you.
Judge, I don't know if you were referring to probable cause.
No, the court does find probable cause. I'm saying in the victim section where it says name of victim, it has the defendant's name instead of the alleged victim's name. But the alleged victim's name is within the content of the probable cause affidavit. Okay?
I understand.
Okay. All right, you want to be heard with regard to the $2,000 bond?
That, yes, Judge.
Sure.
And speaking with Mr. Sealing, he advised me that he's not going to be able to afford to post the bond. He's going to be requesting that the court consider releasing him on pre-trial release, and I'll see if the state has an objection to that before I go any further.
He does. Go ahead.
Judge, I'm speaking with Mr. Sealing. He's 30 years old, been here his whole life. He is working. He works for a restoration hardware company. He's their delivery person. He's been there employed since 2012, so he's been with the same company now for about 6 years.
Okay.
He's living in Miramar. He lives with his girlfriend. They've been residing at that location for about 2 years. His girlfriend basically teaches for a living. From what he advised me, his girlfriend's not in a financial position to post his monetary fund. Judge, we'd be asking you to consider, these are non-violent in nature. Judge, we'd be asking you to consider releasing Mr. Sealing on standard pretrial release.
Your Honor, I believe these are reasonable bonds in light of the fact, based not only on the allegations, but he was placed on 6 months probation by Judge Levy March 29th of this year for theft. So he's currently he's on probation. Just over a week before he was placed on probation, he pled out at first appearance a theft and resisting without violence. 2015, he was convicted of robbery by sudden snatching, burglary of conveyance, and criminal mischief. He violated his probation, was sentenced to 364 days.
Okay, anything further, Mr. Romero?
Not at this time, Judge.
All right, what bond can he afford? Anything?
Maybe his girlfriend or family can come up with half of it. Just, you then leave the bond on $1,000 on count 1 and R1 on 2, or like.
Sure. Standard pretrial release also, okay? 1,000 on 1, ROR on 2. Good luck, sir. David Mark Aldridge.
Mr. Aldridge, come on up, please.
Okay, Mr. Aldridge, you have possession of cocaine, sir. $1,000 bond. You have count 2, possession of alprazolam, which is also known as Xanax, $1,000 bond. Count 3 is drug paraphernalia, possess and/or use, $100 bond. And count 4 is a civil traffic infraction. It's not even for magistrate failure to wear a safety belt.
Just see if
Do you live at 2740 Cypress Ave, Miramar, Florida, sir?
Just hold that there.
All right, anybody want to be heard with regard to bond?
Yes, Judge. We're going to be requesting Mr. Aldridge to be released on standard pretrial. See if the state has an objection.
You.
Go ahead.
Okay. Judge, and seeing Mr. Aldridge, at this time he is working, just got a job working for a company called Miller's Construction. He's getting paid about $10 an hour. He's 52 years old. Been living here in Florida for about 40 years. Right now he's living in Miramar with his sister. Right now his sister is helping him basically with the rent because he's not paying rent at this time. When I asked as far as the sister going to be able to financially afford to put the phone, he advised me no, basically taking care of all the household expenses. He does have fires. However, these are drug offenses. Most likely these are not going to be filed in time. Rather than him staying here in custody for 30 days and then eventually getting released on a warrant, we ask you at this time to release him and be supervised by pretrial release at this time, Judge.
Your Honor, we're going to be opposing pretrial, and frankly, his bond should be increased. He's out on bond right now for felony theft, false ID to law enforcement, and when he was arrested on those new offenses, he had to capias for a trespass. He posted bond on that. He has 19 prior felony convictions, 46 prior misdemeanor convictions, several prior failures to appear, at least 3.
What's the felonies? I mean, are they drug charges? What are they?
Possession of cocaine, grand theft, tampering evidence, theft, battery, cocaine, theft, cocaine and theft, tampering evidence, theft, delivery of cocaine, resisting without violence, loitering and prowling.
All right, so what can he afford
Escape.
for bond?
And tomorrow's his birthday.
She said maybe if the total of the bond was $500, but maybe $500 on count 1 and ROR count 2 and 3. Replace monthly probably.
Okay, standard pretrial release, 500 on 1, ROR on counts 2 and 3. Thank you, sir. Next one is Macklin Love Mituline. Come on up, sir. Sir, you have a carrying concealed firearm, $1,000 bond, counts 2, 3, and 4 have no bonds attached to them. It's basically an ROR. So the court does find probable cause for all counts. Counts 2 is possession of cannabis under 20 grams. Counts 3 and 4 is a red light ticket and a vehicle failed to yield right away with an emergency vehicle. Anybody want to be heard with regard to the $1,000 bond?
No, Judge.
All right, is your address, sir? It says at large. What's your address? Do you have a mailing address?
Right now, he's not Judge. No address.
You don't have any place where we could send mail even, sir, a mailing address?
Actually, I would have no place I'm sleeping at DCF, but I'm probably not going to. I don't really know the address, but it is on, it's located on.
What's the name of the facility?
It's not a facility, it's a house.
See if something pending, see,
Okay.
see in supervision.
All right, well, you're gonna have to, you know how to use a computer, obviously, right?
Yes, ma'am, you probably have to go to the library.
Yeah, if you go to browardclerk.org, or you can call up, or you can come down here, you can find out your court date. So, State?
Your Honor, he was just arrested Saturday, 4:15 in the morning for loitering and prowling. He was ROR'd. The allegations were he and the other young adults he were with were trying to break into cars. He's now before the court 3-4 days later, allegedly drugs and a gun in his possession. He has, it would appear, I'm trying to see if there's anything pending in juvenile court, because
He was on a skateboard?
that's what it says here.
Yeah, he was on a skateboard.
Let's see. He has a link.
Fire truck.
Fire truck or firearm? He has a lengthy.
It says the PM on the skateboard also disregarded the emergency.
Oh, okay. He has a lengthy juvenile history, Your Honor. Very lengthy.
He said he was on probation for failing to complete a program.
Yeah, I don't know. I'm not. I know that's what he said. I can't tell you, he has had multiple pickup orders issued for failing to appear.
All right, court's gonna leave the bond at $1,000.
We'd ask for,
No possession of any firearms, ammunitions, or weapons. Do you understand?
Yes, ma'am.
Yes, Mr. Linder, I'm sorry I cut you
no,
off.
that's what I was going to be requesting.
Okay, thank you. Enrique de Jesus Garcia, please. Okay, Mr. Garcia, you have possession of THC, $1,000 bond. Count 2 is possession of marijuana or cannabis, 20 grams or less. There's no bond, it's basically an ROR. Count 3 is an expired motor vehicle registration over 6 months, first offense. That's actually a civil traffic infraction, it's not for magistrate court. Court does find probable cause. Anybody wish to be heard with regard to the $1,000 bond?
No, Judge.
All right, sir, is your address 6695 Salt Air Terrace, Margate?
Yes.
All right, $1,000 bond it is. Thank you, sir. Kendrick Matthew Telez. I'm
Was
sorry.
posted. No problem.
Okay, Mr. Telez, and then we have, who's that there?
This is the last gentleman, Mr. Malcolm Robinson, I believe.
Come on up, sir.
Trying to get in touch with his attorney, Mr. David Solomon.
I spoke with Mr. Solomon's office. They indicated to me that they are not going to be appearing on Mr. Robinson's behalf, as they do not represent him on this case.
All right, so,
Let me see if he wishes the public defender. Yes, he's gonna be going with us.
okay, you want to recall him for this afternoon, or you want to do it now?
I can do a brief one, Judge.
Sure. Any objection to probable cause, Mr. Reed?
No, Your Honor.
Hey, what are you seeking with regard to bond?
One moment, Your Honor.
What about David Markell? Is he a reset also?
Check with North Broward. They didn't
All right,
specifically
we're
tell
gonna
me.
go to North Broward just for a moment. Okay, North Broward, do you have a David Markell?
You mentioned North Broward, ma'am?
Yes, do you have a David Markell, or is he a medical reset?
1 second.
All right, give me a moment, we're just checking with someone. Yesterday, he was a medical reset deputy.
Yes, I didn't even see him on my roster today. What page is he in? Does he show?
Page 23, Deputy.
23.
3. Yes, medical reset.
All right.
The only person we have left here is Williams, Kathleen.
All right, give me one moment for that.
Okay.
So 5218 is a medical reset. What about Jeremy Cooper?
David Hill, judge, is a member.
Jeremy Cooper.
Asking the same thing.
Does anybody know where Jeremy Cooper is?
I'm being advised right now by his deputy that he's here and refused to attend court.
Okay, all right, so let's go back to you, to Malcolm Robinson. Okay, the court does find probable cause.
Your Honor, I'm going to be requesting.
Let me just say no victim contact.
Sure.
Court's gonna order, sir, no victim contact, direct or indirect, with the alleged victim in the case with the initials AH. That means no contact in person, no calling, no texting, no writing, no contact through third parties, and certainly, sir, no contact through social media. Go ahead, State.
Your Honor, I'm going to be asking for a $20,000 bond, pretrial release of the GPS, no possession of any firearms, ammunition, or weapons until further order of the court. I'm not only concerned, Your Honor, based on the allegations and the evidence that's listed in the report, Your Honor, but the case that he's represented by counsel on, it's a pending carry and conceal firearm that he's out of custody on.
You mean David,
Yes.
David Solomon on the other case?
Yes, so he's out on bond on a firearm offense, and now he's alleged threatening someone with a firearm. Yes.
Okay, I remember. All right, go ahead, defense.
Judge, my understanding as far as Mr. Robinson, the case that Mr. Lender referred to, that's currently pending, I believe, is represented by Mr. Solomon. Mr. Robinson advised he's been going to court and fighting that charge without hearing the post resolution. He believes that he is going to be dropping that case. Having said that, Judge, I'm 23 years old. He's been here in South Florida his whole entire life. He is working. He works at 6 months, maybe theater. He's been working there for about 2 years now. He's about $13 an hour. He has 2 kids. He lives with his mom in Coral Springs. Basically, one of the children lives with him. The other child lives with his birth mom. He provides financial support to his children and his mother does, as far as rent posted bonds, from what he advised me, what his mom does, she's in billing. She doesn't know exactly how much she makes, but he does not believe it's a lot. Judge, we'd be asking you to consider, setting a $2,000 bond on Mr. Robbins' behalf on this case.
Further state?
No, ma'am.
Okay, court's gonna set bond at $20,000. Court notes he does have another pending case. No victim contact, direct or indirect, with the alleged victim, AH, no possession of firearms, ammunition, or weapons. GPS level 2 if he does bond. Thank you, sir. Good luck to you. Okay, we have Jeremy Cooper. Okay, Mr. Romero, we'll see you back at 1.
I guess,
Okay, Jeremy Cooper at main jail. Mr. Romero,
I think,
you said that Jeremy Cooper's at the main jail and refused?
That's what the deputies informed me right now, Judge.
Okay, he voluntarily absented himself from court.
Shame, because it's probably something we might be able to work out.
it's a felony.
Oh, it's a felon. Oh, that's right. Yeah, he's got priors. Yeah. Okay.
Does he have any no bond holds or anything?
I think this is it.
I think this is it, Judge. I mean, yeah, I didn't see anything else.
Your Honor,
Does he have any priors?
he has 2 cases, it appears, that's open.
Okay.
Oh, he
One is
does.
being supervised by pretrial, aggravated battery on an officer and petty theft, case 18-440-4 CF-10A. And then there's another one, 18-2269, that's also open. That's a grand theft in the 3rd degree. If this court does find probable cause, we're gonna ask that his pretrial status be revoked.
I'll leave that to the division judge.
No problem, thank you.
All right, so $749. He's at the main jail. He voluntarily absented himself from court, refused to appear. So it's that one. All right, we'll see you at 1 o'clock.
Yes, Judge.
Bye. All right, so can I have the statute number? Let's recall Miss Caitlin Leah Williams, please.
Hello, Judge.
Hi, how are you?
I'm fine. How are you?
Good.
So, Your Honor, as far as,
Can I have a statute number?
yes, it's, okay, 938.27. Should I call back?
938.
Okay, yeah, bye-bye. 938.27. 1 and 2. No, it's 938.27. 1 and 2.
Okay, which subsection you sent me to? Let me read it.
1 and 2.
2A?
Yeah, 1 and 2A. No, I think 2A.
What are we discussing about
Cost
whether
of
she has to pay
prosecution.
cost of prosecution?
Whether they have to be imposed.
No, not whether they have to be imposed, whether you can work them off of community service.
That's not imposing cost of prosecution, that's imposing community service.
I'm not arguing with you, I'm just saying.
I gotta go upstairs, see you guys later.
Okay, I plan on kind of staying out of this, but go ahead.
Your Honor, in 2A, the court shall require the defendant to pay the cost, not do community service hours instead of the cost. Pay. Payment has to be money. And this doesn't say may, it says the court shall.
And I am imposing the cost of prosecution.
Not by allowing, Your Honor, not by allowing community service hours for the cost of prosecution. Because costs can't be paid with community service hours, and the statute itself says the court shall require the defendant to pay the costs within a specified period. And it says, and it even says, the court shall impose the cost of prosecution investigation notwithstanding the defendant's present ability to pay.
Well, that's if you don't impose them. I consider I am imposing them because she is having to pay by community service.
Your Honor,
Let me finish. I'm not arguing with you about this. It's just a discussion. That's the way I'm looking at this.
I understand your, all right, go ahead.
Costs are imposed all the time. Portion of it you can't pay by community service, but you're saying
No,
or other things. You're
no,
saying no community service as well?
I believe, Your Honor, under the statute, now it's not, I don't know that it's I'm just arguing cost of prosecution at this point. I think, Your Honor, if I could, okay. I think if the clerk's office has issue with, that for the court issuing community service instead of their fees, that might be for the clerk's office to argue. I'm arguing cost of prosecution. As I imagine, if the court started allowing community service instead of fees for paying the application for the public defender's office, the public defender's office might have an argument against that as well. Your Honor, I'm dealing specifically with this statute, and the statute specifically says, 1, the court shall impose the cost of prosecution and investigation notwithstanding the defendant's present ability to pay. The obvious interpretation is, obviously, a monetary amount has to be imposed. If it wasn't monetary, then it wouldn't even, the statute wouldn't even mention ability to pay. It wouldn't be a consideration. There would be no reason to have that language. Secondly, the court shall require the defendant to pay the cost. Performing a community service hour is not a payment. It is an action. It is volunteer work. It is not a payment. The plain language of the statute requires for cost of prosecution that they must be imposed. Now, it does give alternative, then gives, if the defendant is not able to make payments, then the statute covers actions she can take with the clerk's office. But there is nothing in the statute that permits this court to do anything other than impose a monetary cost of prosecution.
Okay, let me ask you this, then how come with regard to court costs, on these disposition sheets that you see, courts allow people to work off court costs with community service?
That doesn't mean that the courts are, just because the courts have been doing it and the clerk's office doesn't object, doesn't make it lawful. I'm referring to the statute, which clearly is more, has more authority than a form that the clerk's office prepares.
All right, so this is what the court's gonna do. We took her plea, right?
Yes, Judge.
Okay, so withholding court costs, $293, 6 months on one, 1 year on the other one. Court is gonna give you, I respectfully decline and deny your request, Mr. Linder. Court is gonna allow community service at the rate of $10 per hour. And I will do this on only one of the 293. The other one you do have to pay, okay?
Well, Your Honor, I am objecting for the record and noting.
I understand, I heard your objection.
I understand, Your Honor, but I have to make a record. I'm making a record not for the. I understand, Your Honor, but I have to be able to make a record, Your Honor. If the state chooses to appeal, I have to be able to make a record, Your Honor. If I'm not able to make that record, then it's not a complete record.
Okay, make your record, and then I want to say something, because in this courtroom, everybody has a habit of, after I make in my ruling, of adding more comments. So,
Your Honor, that's.
Let me finish, Mr. Linder.
Yes, ma'am.
It's very frustrating when always, every time I do something someone doesn't really like, I always hear an argument from either side, and I don't think it's appropriate. But go ahead, I will allow you leeway to make your record for what you haven't said already.
First, Your Honor, I'm objecting, and the basis for my objection is it's violative of the statute. Secondly, Your Honor, I'm objecting because my concern is that the court has allowed community service hours in the past, and on this case, for cost of prosecution. In my experience before the court, I've never seen the court allow community service in place of filing fees or application fees for the public defender's office. So it is a concern that the court is allowing community service to replace costs to one side of the state employees, in this case the state attorney's office, but doesn't allow it or doesn't order it for the other side, and there's supposed to be equal treatment of both sides. And Your Honor, as far as the court's last response, this is not an argument with the court. It is commonplace in a criminal matter that if either side takes issue and may choose to appeal, they have to be given an opportunity to lay a complete record, because that's the only thing that can be relied upon if there's an appeal taken either to a circuit court judge or the 4th DCA. And it's nothing personal against this court.
I'm not taking it personal. But, so what you're telling me is, it's appropriate in every instance that I make a ruling for that you don't like or the defense doesn't like, and by you I mean the state, you mean it's okay for both of you, for either of you or both of you, to make another argument on top of that and note something for the record.
And it's not about whether and I'll speak for myself, it's not about whether I like the ruling or not. If I believe the law does not support the ruling, and I want to make it very clear what my issue is, and I don't believe I've done and limited my issue specifically in a succinct statement, I believe I'm asking for the opportunity to make that record extremely clear. I don't know that it's an issue that I don't know why the court is concerned with me making that statement, because as I stated, and the court agreed, it's not. I know, but I'm just speaking for myself, Your Honor. I know it's not just me.
I want to make the record clear myself that it's not just you. You're making it like I'm picking on you, and I'm certainly not.
No, I don't think you're picking on me, Your Honor. What I'm saying is that, as the court just stated, it's not personal. You do not believe it's personal. Then there shouldn't be any issue with making a statement just to make the record as clear and concise as possible.
Okay. Anything else?
No, Your Honor.
Anything from the defense? All right, thank you. We'll be back at 1. Okay, ma'am, good luck to you. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You do have to pay
30 days for what?
to appeal the sentence of the court. If you can't afford an attorney, one will be appointed, okay?
Okay, what does that mean?
You don't want to appeal, you got time served. You can appeal if you want to, but there really isn't anything to appeal. Make sure you take care of those court costs. Apparently, Mr. Lender is very sensitive about that issue, okay? Good luck, Ms. Williams.
Thank you.